hearing, as you're all well aware, is the party shall have the right to call and examine witnesses, introduce exhibits, cross-examine witnesses, submit evidence, make objections, bring motions, and make oral arguments. Cross-examination shall occur immediately after any witness testimony has been received, although redirect and cross-examination is in my discretion. Typically, I always allow it. So if you want to redirect or recross, feel free to. The petitioners will present his case first. The parties are free to make an opening argument. Frankly, I don't need to hear an opening argument. I've been involved with this case as you have for 2 years. I've heard motions to dismiss, a motion for summary decision. But if the party wants to make a brief opening statement, you're free to do so. But candidly, I don't really need it. I'll defer to you. My function as a presiding officer is to preside over the taking of evidence, to rule on objections to the evidence, and on any non-dispositive motions. The parties may make closing arguments at the close of the evidence, and that'll probably be referred to the entire commission. A record of this proceeding, including a copy of the transcript, exhibits, and briefs, will be forwarded to the full commission for its consideration, and I will participate in these deliberations. As the parties know, the formal rules of evidence do not apply to this hearing. Evidence will be admitted if it is relevant, not privileged, and it's the kind of evidence which reasonable people are accustomed to relying to in the conduct of their serious affairs.
Sir, I'm sorry to interrupt. Could you please just keep your voice?
I should have given you this. I apologize. I'm flying through this, and I apologize to you. So I'll repeat myself. I remind the parties that the formal rules of evidence do not apply to this hearing. Evidence will be admitted if it is relevant and not privileged, and it's the kind of evidence which reasonable persons are accustomed to in serious affairs. Delays may occur, obviously, and video cameras should be turned on during the entire hearing until I announce a break, at which point participants should turn off the cameras and mute themselves until the hearing is scheduled to resume after the break. And furthermore, I continue to hope and expect that all will conduct themselves in a respectful manner. So that's it for my preliminary. So if anybody wants to take a break, just let me know. Just raise your hand and say you want to take a short break. I'll always say yes. As for lunch, I'm deferring to the court model, which you're very well aware. We typically do it at 1. However, if the parties want to do it earlier, I'm amenable to that. If a witness ends at 12:30 or 12:45, I may take a break at that point. So if any parties have any problems, considerations, questions, please ask, Mr. Kylie.
There are a number of us here.
Right.
Bathroom breaks do not follow a regular schedule. If can we exercise our own judgment, indicate to you in some way that we're going to visit the men's room and have the hearing continue?
Yeah, well, it's up to you because, as Mr. Bourgeois has indicated in some of his preliminary motions and comments, it's not necessary for, you're welcome to be here the entire hearing, but it's not necessary that if witness X is not testifying against your client, you may not even want to be here. If you want to be here, that's fine. If you don't want to be here, that's fine.
Without interrupting the proceeding, be my client and my associate here if I need to, without stopping everything. That's what I'm asking.
Yeah, if two things. If you want to just excuse yourself, that's absolutely fine. If you want to take a break in the action because it's significant what you're listening to, just let me know. We'll take a break. That's not going to be a problem. So at any point, if somebody wants to get up and use the facilities, please feel free to. Do me a favor, do not trip over the wire if you so do. If you so want doing that. So to start, does anybody else have any questions before I start weighing in on the motions in limine, of which there were several? So, I've indicated a few times now, my inclination is if I have the discretion to admit evidence, I'm going to admit evidence. It's my belief that the more evidence that's before the tribunal, the greater likelihood a just and fair resolution will be arrived at. So I'm just going to start with the motion in limine to exclude certain testimony filed by the petitioner. moving to testimonies of full witness of respondent Early. Bearing in mind what I just said, do you want a very brief?
Should I go to the podium or just here is fine?
This
or-
is fine, wherever you're comfortable. If you're comfortable there, I'm comfortable.
So we are moving to testimonies of Joanne Peterson, Margaret Brownbaugh, Mary Beth Adams. That's the one we're talking about.
That's the
now.
one we're
Yes.
talking about, and I've read I've read all of them, I've read your motion, so, you know, if you want to highlight some, please feel free to.
Sure, this is not a case about addiction, dual diagnosis, exploitation of women. One of the witnesses is being called to testify as to the mental concerns of the arrestee in this case. There's no indication that the arrestee has been contacted as to whether or not that information should be discussed or discussed publicly. It is unnecessary. This is a case about revising her arrest report and attempting to replace it with the original.
Okay, well, I appreciate that well-written motion. Does the respondent want to very briefly be heard, bearing in mind what I just said?
Yes, but what you didn't say, Your Honor, is was.
I did, sure.
So our position is we're both entitled. We see a different side to the case. The case is, from our perspective, is about the performance of the attorney. And his actions with respect to compassion. Witnesses, if you think they end up being repetitive, you have the power to exclude it along the way. I think the motion should be denied and the material is allowed to testify subject to rationale.
Thank you, Mr. Rusconi. You filed a motion in opposition. I've read it. You want to briefly be heard?
Just that I think I made myself pretty clear in the first bullet point. I don't think I need to belabor it any further. You've read it. I just rest on papers.
Okay, thank you. The motion is denied, subject to, if the testimony starts coming in and you think it's going too far afield and it's not relevant, please, renew your objection and I'll revisit it at that point. Okay, motion to eliminate to exclude the testimony of Attorney Kiley. Once again, I have read everything that's been submitted, including the opposition, and does, let's see, okay, Ms. Pruitt, are you still on that slot?
Yes, please.
Okay.
Attorney Kiley has been counsel for Mr. Early since AG's office was investigating. Conducted by the Ethics Commission and throughout the course of this adjudication. And now he has listed himself as a witness in the case that violates the professional conduct. He's had an opportunity to shape his client's case, and then he can shape his testimony to fit his view of the case. It is prejudicial. It is against the rules of professional conduct, and it should not be allowed. He can't be both witness and counsel.
Okay, I appreciate that. Ms. Rusconi,
Yes.
okay, which is.
For the most part, I'll just rest on our papers, but I will say, Mr. Kiley is an officer of the court. He understands his professional responsibilities. He might not be a necessary witness. Mr. Early obviously we can elicit that same testimony. And I think that, the hearing officer is perfectly capable of hearing the evidence and not being overly prejudiced by Mr. Kiley's status as an attorney. And there's no evidence whatsoever that Mr. Kiley has ever misrepresented that he, has said that he's represented Mr. Early from the beginning. There's no evidence that anyone ever asked him if he gave advice to Early on the subject and that he said no. So there's really, there's no prejudice, so thank you.
Okay, thank you, Ms. Fierro. I think I misidentified.
No problem whatsoever.
Judge, may I just say that this is clearly something you as a presiding officer and based on experience as a judge for, I don't want to say how many years, you're more than capable of discerning the accuracy and credibility of witness. And I don't think that would be any problem for you to the same thing.
I appreciate that and I thank you. Okay, that motion is denied. So, a motion to eliminate to exclude Clerk Keenan's answers to written deposition questions. Ms. Pro, you still up at that?
Excuse me. Sorry.
What's that?
Excuse me, Ms. Pruitt, the attendees of the public are having some trouble hearing counsel. So would you please keep your voice up? Apparently the presiding officer is coming through loud and clear. But just remember to keep your voice up so that the microphone can pick it up so that the people attending on Zoom will be able to hear you. Thank you.
And am I correct that there's a microphone here next to the podium, but
Yes.
not a microphone at the petitioner's table? Okay, great. I'm sorry, which motion eliminates this?
They're doing the motion to eliminate to exclude clerk's answers to written.
So we're calling Keenan as a witness, and he can testify. He can provide live testimony. So one, his deposition questions should not be allowed in. But also, some of the deposition questions are improper. So he was provided with transcripts of individuals with whom he had no communication, no interaction, and then asked to comment on those interview questions. So the questions were improper. He's testifying. His deposition questions should not come in.
Okay, I appreciate your argument. I take it, Ms. Bourgeois, you want to be heard on this?
Just briefly, and to say, Your Honor, that the deposition on written questions of Mr. Keenan was the only opportunity that he had to provide accurate information, not in response to leading questions and with the assistance of counsel in a relaxed environment. It's more probative than any of the other testimony, and it ought to be allowed.
Okay, I'm denying the motion. And, I'm very confident that through your cross-examination, you'll be able to ferret out any weaknesses of the testimony. So next motion, eliminate to admit respondent's sworn interview. The petitioner seeks to admit and make part of the record excerpts of testimony given by the four respondents. So do you want to be, is this still, okay, Ms. Pro, you're still at that? Yeah, thank you. Can't hear you if you're whispering.
On this motion, this is the motion to allow the Attorney General office interviews.
This is the motion to eliminate to admit respondent sworn interview excerpts
Oh, my goodness, yes.
into
Sorry.
evidence.
I
So,
apologize.
no, I apologize to you. I did not make myself clear.
Thank you so much. So these are the respondents' own statements. Under oath.
Sure.
Represented by counsel. And they are presumably truthful statements. They should be allowed in the record.
Okay, well, I appreciate that. Ms. Hurley?
Doctrine of completeness, they're going to come in, statements should come in. I've been advocating for the admission of transcripts and sworn testimony all along.
You want to be heard on that?
Absolutely. The respondents have identified no statements that were not complete, and they had the opportunity to do so. We provided them in enough time. They could have objected to them. They could have provided, whatever was incomplete about the statements. They didn't. The excerpt should be allowed in.
Okay, well, yeah, Mr.
And if you recall, one of the issues that we talked about with regard to stipulations was that the AG's report, for instance, wasn't under oath. It did not provide us with the opportunity to cross-examine. We certainly made an objection to that coming in. And what Mr. Kiley has just said, it's important if you're going to introduce the entire context of the interview, it should all come in. And, if they have any questions about that, they can call our clients. They've already filed a motion to have them declared hostile witnesses. They can call them and cross-examine them with those statements, but it should be the entirety of the interview.
Okay.
Your Honor.
Oh, yeah, I'm sorry.
Just briefly, I agree with the position of both the other respondents counsel. And in addition, Mr. Travers submitted an errata sheet associated with his interview.
Okay.
Where certain questions and testimony was taken out long. That should also go in as well under the document completion. It should all go in, the sworn statements only.
Okay. Okay, so I agree with you. So the motion's allowed, subject to the entire statements coming in. Okay, thank you. Okay, respondent, oops. Okay, this is a petitioner's motion in limine on admission of Attorney General's office interview transcripts and memoranda of interviews.
Thank you. Good morning, Commissioner John McDonald for the petitioner. We're seeking to admit the Attorney General's office interview transcripts of 5 of the state troopers and the memorandum of interviews of a couple of the district attorneys, and rely on the basis for the motion that I submitted in the written brief. It's the type of evidence that should be brought into a hearing like this that reasonable people would rely on.
Okay, so these are interviews of these witnesses.
Attorney General's office interviews of the witnesses. We have the transcripts. It was actually suggested by Attorney Kiley initially that this might be a way to shorten the need of calling witnesses in.
I appreciate that.
Reached a stipulation on it, unfortunately, but we are asking that you admit those interview transcripts as well as the memorandum to district attorneys.
Okay, I could note, I did not receive an opposition to this, but do parties want to be heard?
The motions were filed Monday. We have 7. I
Okay,
think what we talked about was that we would deal with things orally today.
Yeah.
To be clear, I think we're talking about, and I think we talked about this again, the excerpts of interviews with state police officers.
That's correct.
So and it's transcripts.
The Office of Attorney General interview transcripts will be of state police troopers Conant, Robert Johnson, Dean Ricciardi, James Fogarty, be the troopers.
So we're talking about a finite piece with transcripts. I did suggest that they come in. All of my efforts have been to save time. I have not. I am in agreement with that motion as long as it's complete.
okay.
But go ahead, Mr.
I think it's important to recognize there are 2 different types of AG documents. There are transcripts, verbatim question and answer. They're not sworn, but I don't think any of the respondents have big problems with that.
Okay.
There's also something they call memoranda of interview. And those are witnesses who decline to be recorded. And what you have is the AG staff's memory of a summarization of what they think they remember the witnesses saying.
Okay.
And there's no question, there's no information about how long after. In the case of Mr. Travers, they're clearly inaccurate, but most importantly, they're not needed because petitioner had an opportunity, and we've already agreed that in its entirety, petitioner's interview of Mr. Travers can go in. They have no need to put in a summary of what someone in the AG's office thinks they remember Mr. Travers is saying. So that should be excluded. It's frankly not the kind of information that a reasonable fact finder would rely on when there is sworn testimony in a transcript already.
Okay, thank you, Mr. McDonald.
We are asking for those memorandum of interviews of Roberto O'Brien and Ed Carcasinis also to come in. The interviews were voluntary. They were represented by counsel. And we think it's a type of information that you should admit along with the transcripts of the Attorney General.
It's a memoranda from a AG saying I spoke to someone and here's what they said to me.
That's correct.
Right, okay,
That's
well,
correct.
okay, that's not going to come in. Other than that, the other documents will come in, okay?
Judge Payne, I just,
Oh, I'm sorry.
yeah. One of the things we had talked about was we had reached some form of a consensus. I was objecting to their introduction initially because there was no opportunity for us to cross. What we agreed to, I believe, was that in the event that that there was a need to bring those witnesses in, they would still be available for potential cross-examination as the case progressed. Is that, is
Sure.
that accurate?
Yeah, that's fine.
There was no agreement on that point. That was,
So I'm
I guess-
asking you, Judge.
No, that's fine. You know, if they want to bring in a witness as a result that something happens
so the-
during this hearing.
we also have time for.
And again, I agree with what counsel had said about the memorandum.
Okay, well, okay, so the memoranda is out.
Okay.
Everything else is in.
Your transcript.
Okay, and if you need to call a witness for any reason, because evidence will be developed, you're free to do that. Yeah.
Can I speak briefly? The main concern we have with this is the transcripts come in based on your ruling, and we understand that if the respondents want to cross-examine a witness, they have the right to call it witness to do it. The concern that we had is this de bene procedure, where somehow if the witness becomes unavailable for cross-examination, there's this notion that the transcript itself is then removed from the proceedings. And we're not agreeing to that, because that would put us.
Bene today.
I believe that's what they're talking about.
Bringing it up.
Maybe
I-
we can clarify if that is or is not what Attorney Burke's talking about, but our concern all along has been that if somehow the transcripts are admitted, we don't need the witnesses. We agree that there would be cross-examination if there was a point that the respondents wanted to raise, but there's been a lot of talk if something unforeseeable happened or something happened that the witness was then not available for cross-examination, that the original transcript would then be pulled from the hearing and no longer in evidence.
Why don't we'll cross that bridge when we get to it.
That would be very difficult for us, because if that does happen, we wouldn't have a witness at that point, because we would have the transcript in, so therefore we would need to call a witness. If there is an attempt to cross-examination, which is fine, that witness doesn't appear for whatever reason, then if the transcript was pulled out, we wouldn't have the testimony of the live witness because they would be unavailable, and the hearing officer potentially could remove the original transcript that was admitted. So we're just trying to sort out that for our case.
Trust me, I appreciate your concerns. And if we arrive at that situation, we'll address it then. Okay, so I've made the ruling. Okay, thank you. Petitioner's motion eliminate to admit the salary information.
We're seeking to admit the 2017 salary information of various identified people. This information is relevant to one of the theories of our case. It's not confidential. It's publicly available. Anyone can go to the state website and see what District Attorney Early made in 2017 to the president or any of the other respondents or any of the other people we're identifying. It's not sensitive information. It's publicly available. It's not confidential. We'd ask you to allow us to admit that evidence in our case.
So in Mr. Cowley's opposition, he talked in paragraph 2, he writes at the end, to satisfy this element of substantial value, the petitioner must prove the monetary value of what the recipient was to receive, not the cost to the state, which sounds somewhat compelling unless you dissuade.
Right. I'd like you to see how that one goes as well, in the sense that we should be entitled to put in the evidence that we think supports our case. That's one of our theories as far as substantial value. And if the evidence does not come in as, how it needs to come in, then I think there could be a ruling on that legal issue when we put in our case. But I think this is premature at the motion to eliminate stage. I think we should be allowed to put in this non-confidential, publicly available information. It supports one of the theories of our case. We'd ask you to allow the motion and eliminate to allow that information in.
Okay, it's okay. What do you have to say?
It's premature. I'm asking you to admit it now without evaluating when I object to its relevance and raising other objections. To have motion.
Okay, I'm going to hold this in abeyance, and then we can argue it at the appropriate time. As I said, I am concerned, frankly, with the point that Attorney Kiley brought up. I realize also I'm just one of 5 commissioners, so so I may, they may have a different feeling than me, and I may admit it if it's something they would want to hear. But so let me just hold that in abeyance for now. Okay.
Thank you.
Next one, motion and eliminate to admit evidence of exhibits from petitioner's exhibit list. And just once again,
Morning, and John McDonald for the petitioner. This is a list of various items that we were not able to reach stipulations on that we would like admitted. The authenticity of the exhibits is not in question. The respondents have also had these exhibits since at least October 20th of 2020, and it's the type of evidence that reasonable persons rely on the conduct of serious affairs. Also based on your earlier statements that you'd be inclined to admit evidence and then rule on its relevancy, we'd ask you to admit the evidence, these exhibits from the petition's exhibit list.
Okay, I read Mr. Attorney Bourgeois' response to that, and he is asking that the affidavit of Roberta O'Brien be admitted. What are your thoughts on that?
Roberta O'Brien is a witness that we may call in our case, and then we would have live testimony. And I think that's much more relevant than an affidavit that was created very recently in anticipation of litigation. So I think if you have a live witness to testify, that's a type of evidence that you as a presiding officer should consider to evaluate the witness's credibility while she's sitting right here in front of you.
I appreciate that. Mr. Bourgeois, absolutely.
The problem with that argument is that my brother wants the transcript in now, but without Roberta O'Brien. So if he doesn't call her, you have a transcript which frankly is offered for the purpose of they are trying to change the judge's endorsement on the motion, the text of the motion, and the docket based upon something that the judge said in the hearing. The only person who heard those words is Roberta O'Brien. She has given an affidavit that says, I never told anybody in the office what the judge said. And I find it amazing that people would want to create, using a transcript made 3 years after the fact, a different environment than the one in which all the respondents functioned in. Nobody at the time thought that this impoundment order was time limited. And the business about objecting because it's a recent affidavit makes no sense. They're talking about even more recent live testimony from her. She's given a sworn statement. She is also an officer of the court. She said what she said, and that transcript should not go in without her statement.
Okay, so everything goes in. Yeah,
I'm sorry. I didn't get up fast enough. On behalf of Respondent Early, we do have an objection just to one of these exhibits, number 6, the report writing PowerPoint by Mark Hannon. We've received no information about this Mark Hannon. He's not on petitioner's witness list. Don't see the relevance of the PowerPoint. And if petitioner wants to bring this PowerPoint in, they should be required to do it in the normal course, which is introduce it through the arresting trooper if he saw this PowerPoint, or the person who actually
referring to
Item 9.
Oh,
Go to
okay.
tab 9, item
Okay.
6.
Okay, so it's item 6,
item 6,
the report writing PowerPoint.
correct.
Okay, so what is your objection to that?
This trooper Mark Hannon, we've received no information about him, who apparently created the PowerPoint. He's not on the petitioner's witness list. We don't see the relevance of this report writing PowerPoint, and petitioner should be required, instead of getting it admitted, in advance, to put it in evidence in the normal course, introduce it if it's relevant. If the arresting trooper, this was part of his training, they should be required to put it in through the arresting trooper.
So have you seen this?
We've seen it.
You have seen the
I've seen
PowerPoint.
it. Yes.
And is this, and do you want this trooper, is this trooper testifying?
That trooper is not testifying. We have a witness that is going to testify today, Jamie McKeon, and we're going to ask him about that PowerPoint.
If Jamie McKeon didn't create the PowerPoint, again, this should not be something that's admitted in advance. If they can get it in through McKeon, then let them try.
Okay, what I'm going to do is, for now, I'm going to allow the motion with the exception of number 6, and I'm going to rule that. I'll put that in.
Thank you, Judge.
But I'll rule on that at the
Thank you.
appropriate time. So,
Your Honor, can I get a point of clarification?
sure.
My understanding is that they have moved to admit the recording of the impoundment hearing, not the transcript made of the recording. And my understanding is your ruling is the recording goes in and the affidavit of Roberta O'Brien goes in.
Yes.
Thank
Yeah. Okay. Okay. Let me just get to. I'm hopping around a little. Let me just get to. Let me give motion to eliminate a call respondents as adverse witnesses. Seems fairly routine. So you're giving me it's a fairly routine motion, and I said, okay,
And as a matter of routine, we'll be able to ask leading questions if our witnesses are called with respect to the subject matter of the testimony, and be allowed to do our own direct case with our witnesses subsequently.
That's correct.
Thank you.
Okay.
We can call them as adverse witnesses. Counsel can cross-examine them as adverse witnesses and then call them again in their case in chief. Is that?
Well, that they can, but I'm assuming that once the witness is called, that's the one and only time we'll hear from him, but I'll
Sure.
refer to you.
that
You
was
know,
what that was-
that's what I would prefer, but if you want to do it as Ms. Pruitt indicated, that's your call.
I believe it is. Yeah. Normal procedure, calling an adverse party's counsel is to cross-examine, essentially ask leading questions of the subject.
Okay.
And then what we do with respect to the things that are not subject is our call, I believe.
Your call. Yeah, your call. Okay. And once they call a witness, you could introduce whatever testimony you want. So, it's, okay, so that's allowed. Okay, now I'm the last motion, two motions from Attorney Bourgeois. No, I'm sorry. This is, I'll get to Attorney Bourgeois' motion. This is a motion to lift protective order concerning AG's office records. And is Ms. Pruitt, are you continuing to argue this?
Yes,
Okay.
I believe that at the last opening. Candice Pruitt representing the petition. I believe at the final pretrial conference, you indicated that if we wanted you to lift the protective order, we could ask you to do so. The parties have stipulated to numerous exhibits that were subject to the protective order. We have redacted the information that was identified as confidential in those records, such as the home address and social security number, and all of those things that the commission also requires that we redact. And so we just want to be able to use the records as redacted for all purposes in this adjudicatory
I
proceeding.
appreciate that. Ms. Kiley, what do you have to say? I noticed you filed an opposition.
Yeah, and unusual.
Yeah.
Unlike the last matter, this is unusual.
Right.
This case is about redactions. The case itself is about redactions, and whether it was proper to take them. The standards that are in the commission's regs narrow with respect to the material. In the world at large, there are ongoing developmental piece. There are numerous other pieces of confidential information. I attached the addendum to the court rules. I think if the materials are going in, I would urge the actions be more complete and that they address concerns of the court with respect to the actions.
Okay, well,
I'd have more redactions rather than less, and I'd conform to the rules of the court.
so, see, it's hard for me to rule because I don't know specifically what redactions you're talking to. So what I'm going to do, if it's okay, is that we'll take it during a break in the action at some point. I'm just going to ask Commissioner to sit down with the parties, go over the documents and see what it is precisely you want redacted. Maybe folks can come to an agreement, and if you can't, he'll make the call.
But if I may, Commissioner, so our motion is to lift the protective order. And the Attorney General's protective order that you entered is very specific about the type of information that we're trying to protect. That information has been removed. If the concern is about certain statements that were made, those statements have been put in, motions for summary decision. It's already part of the public record. So I'm not entirely certain with what Mr. Kiley is suggesting, but the attorney, the protective order is specific. We've met the requirements of the protective order, so we're asking that it be lifted.
Well, as I indicated, I'm not quite sure what redactions that Attorney Kiley is referring to. So in fairness to everybody, I'll just ask at some time over either today or the next few days or whenever you sit down with Commissioner Edwards and discuss it. So we're all on the same page. As I'm inclined to allow them, subject to that, I would allow your motion, obviously. So, but I just want Commissioner Edwards to just have a brief look to see.
We break sooner
Then
rather than
later.
later so that we can show the exhibits to our witness, which I'll talk about momentarily.
Okay. Okay. If you have to show the document to the witness, you can show it to Mr. Kiley first. And then if he has an objection, then he can voice the objection at that point. As I said, I'm inclined to allow the motion. So,
They stipulated to the documents we would be showing the witness.
okay. So, okay. So I think I've made my decision. And last, I think this is the last one. It's Respondent Travers' motion to vacate the order of consolidation. I also remember an earlier motion that you had filed, and I'm very sympathetic to, if it's an 8-day hearing and they're talking about your client for 1 day, why you should be here for the other 7 days. So I'm very sympathetic. Yeah, Mr. Trump, what do you say?
First of all, I appreciate your sympathy and I believe in your group. But I have to be frank, the petitioner doesn't.
Okay.
We've been unable to reach any stipulations that would have cut down my involvement. You have a motion for a procedural order where I've asked that 2 witnesses be taken back to back. They oppose it. As late as this morning, petitioner informed Mr. Kiley, but not me, who their witness would be today. So the goodwill that you've expressed to me, and I appreciate it, it's not going to come from the other side. So what I suggest to you is that as you weigh 2 things, you weigh the hardship to the petitioner of having to do a separate case against Travers, which is going to take a day and a half after this is all over. The hardship to Mr. Travers of having what's now scheduled 9 days of hearing, and we've only got maybe 2 witnesses this week or 3. The balancing of that hardship dictates that you should rescind the order of consolidation. Certainly, if you don't, I have to ask you for that procedural order, but I think it's time to let Mr. Travers out of this case. The punishment of being in this case financially on him is worse than anything the commission could do to him.
Right. No, I'm very sympathetic to that, as I indicated. Well, short of allowing your motion, how can we minimize this hardship? And I suppose one way is that I could suggest or order the petitioner to call those 2 witnesses on a day certain.
I've been trying cases for 40 years, and I've never had to ask a judge for an order of this type. Usually you just get it from the other side. But in this situation, what we would need is clear articulation of a witness batting order in advance so that next week I would know who the witness is going to be. I would need cooperation for the witnesses that I need to be here for. But at the end of the day, the case, if Travers' case was tried alone, it would be a day and a half case. Nobody become embroiled in what's going now a 12-day schedule and a 9-day schedule, and probably going to be 12 or 15.
Objection.
It just doesn't make sense. And you're not going to change petitioner's attitude.
Okay.
They're not going to do anything that they don't have to do.
Okay. Well,
And so far, they haven't felt any need for courtesy or communication with me.
Okay. Well, let me just then turn to the petitioner and ask what we're going to do to address these, in my view, legitimate concerns. For you certainly are getting exercises.
Getting all her steps in.
If we had a microphone on this side, I would have to continue to get up, but we don't, so.
Maybe we can make.
I'll do what must be done.
Okay.
So, I don't see how helpful it would be to go through the whole history of the petitioner's attempt to
I
enter
agree.
into stipulations
Okay.
with the respondents, taking their motions and their statements of fact and indicating what we would agree to,
Okay.
then meeting with them, and then, accepting their changes only to have them object again.
I recognize.
We're actually,
I recognize that there's been some antipathy between the parties up to this point. So hopefully, starting today and going forward, that's going to end. So what can you do? What can you do to address Mr. Bourgeois', in my view, legitimate complaints?
Yeah, I mean, Mr. Bourgeois, frankly, agreed on the dates of the hearing. He participated in setting the dates of the hearing. I believe he said he would be in town this week, but then not next week. So I wasn't sure what his plan was in terms of, doing the cross-examination of witnesses or presenting his own case from Arizona, where he moved to. This case should not be bifurcated. There are common issues between the parties. There are common witnesses. There are common facts. The idea of dropping, just visualizing, we're prosecuting a case, and then he wants to drop the defendant in the middle of our case. And that's only for tactical purposes. It's not for money. He could do that remotely. And also, as the commissioner noted, he doesn't have to be here for the entire hearing. None of the council have to be here for the entire.
I understand what you're saying, but you're not really helping me here. So what are you going to do? I want you to stay there because I've asked you a question. What are you going to do to accommodate his, in my view? Well, let me just back up. He says if I sever the case, it's a 1.5-day case. You obviously disagree with that.
I'm not entirely sure that that's true. And it's interesting. In one filing, he says there's only one witness that you need to hear from. And as he was standing here at the podium, he was talking about he needed to line up of the witnesses, and then he needed to figure out what he was going to do with his witnesses, or when he was going to present his witnesses. I don't know what witnesses he's talking about other than Clerk Brendan Keenan. So I don't know how I can accommodate him.
Well, you're forcing me to allow his motion with your answer, because I've indicated to you he's suffering a hardship, which I'm respectful of. And I'm turning to you to tell me what you're going to do to assist in his legitimate concerns. And you're basically not giving me an answer. So let me make it easy for you, because I don't want to allow his motion. But you got to work with us here. You got to work with me here. So during the break, I'm going to ask you two to sit down and see if you could hammer out a schedule that's agreeable to both of you to proceed, with the main witnesses against Mr. Travers on whether it's tomorrow or a week from tomorrow or whenever. So that way he doesn't have to come in, other than 1 or 2 days, he's going to be addressing his client.
It was my understanding that Mr. Bourgeois was not going to be in Massachusetts after this week. Is that correct? Am I misunderstanding what you said a few weeks ago, Council? And I apologize for addressing him directly.
If I may answer, my plan was, I always assumed that this would be a meaningful first week packed with a lot of witnesses.
Right.
It's not. It was a waste of time coming here. I want to be here live for Mr. Keenan and Mr. Travers' testimony. But my sister, as she just pointed out, is not going to call them absent an order that they be called that way. So, and let me say one last thing. I don't want sympathy. I didn't retire because I wanted to. I retired for medical reasons. I think the chair knows that.
Right.
So, but the answer to your question is, what are they going to do? You just heard it. They're not going to do anything.
Well, they're gonna have to do something unless if they don't, we're not gonna, I'm gonna have to allow the motion. So
So,
I'm just giving you I don't want to allow the motion. I'm telling you, I don't want to, but if you're not gonna have some type of accommodation and address legitimate concerns, I'll have no choice other than to allow the motion. So I'm turning to you to help me out here.
I have an accommodation.
Okay.
We will call Brendan Keenan on a date certain.
Okay.
At the end of our case, and then he can call his client.
Okay, so on what day is that?
What we do, we need to talk to Mr. Keenan to find out when he's available. And we'll do that. It will be at the end of our case. And that addresses concern of our witness and his client being able to testify on the same day so that the hearing officer can judge their credibilities. Because that's what this is about. This is tactical. We're willing to agree with that.
She said she'll give you a date certain when 2 witnesses will testify. And also, I would hope that you're going to give all the parties the batting order of your witnesses and, when you anticipate calling them. Yeah, Mr. Berthold.
Judge, throughout the course of our interactions, I've stood in front of you, talked in front of you and said repeatedly, using the baseball metaphor, you go out at the opening, before the opening pitch, and you give them the batting order and you give us. You have encouraged good faith and responsible conduct between the parties.
Okay.
At 9:26 this morning, we find out for the first time who the witness is going to be here today. Yesterday, we found out they had no witnesses. This has been going on for 4 years. And this is the kind of interaction. And I don't want to keep pointing a finger and saying, this is what's happening, but Judge, it's a fact.
Okay.
And we're here today for the first time, learning who their witness is an hour before the presentation of the case. That's not fair to us. It's not fair to Mr. Bourgeois or anybody else here.
Okay, well, I appreciate those concerns, and Ms. Pruitt is going to give us, she's going to tell us what she wishes to tell us.
So I expected that we might get to this later, and maybe now is just as good a time to deal with it as any. There is a dearth of witnesses for the petitioner this week. And I believe the presiding officer knows that as of yesterday, we did not have any witnesses. 5 days ago, we had 3 witnesses scheduled for today, 3 witnesses scheduled for tomorrow, and 2 witnesses scheduled for Friday. And 5 days ago, you ordered us to focus our attention and our resources on the discrete issue of substantial value. And so we dropped everything and we did that. Our day 1 witnesses were not being called to testify as to substantial value. Our day 2 witnesses weren't scheduled to testify as to substantial value. You also told us when we spoke to our witness to be sure to blame you for the order.
I'm sure you did. So.
We did.
Okay.
In fact, we did.
Okay.
We moved Ryan Sevier from Friday to today. We advised his counsel that he would be testifying, his counsel, Lenny Cassidy, he would be testifying to the discrete issue of substantial value. And we canceled the rest of the witnesses because we knew that we were putting all our focus, our time, our preparation on substantial value. And then yesterday, the order was rescinded.
So I take it that you called these 8 witnesses up. You continue to blame me, which is fine. And you said, remember 4 days ago, I said, I wouldn't need you, today or tomorrow. Well, I need you today or tomorrow. So you're telling me that 8 witnesses have become unavailable, in 5 days.
And so what I will tell you is, again, we had a plan for how we were going to present this case. We had a plan for how we were going to prep these witnesses to testify. We abandoned all of those plans to focus on the discrete issue of substantial value. So the 2 of the witnesses that we intended to call today haven't been prepped to testify because we focused on substantial value. And you said that after we presented our evidence on substantial value, then you would decide what you wanted to do next. We had no idea what it was that you were going to want to do next after that. So one of the witnesses of the three that we were calling on the first day is on his way here, and he's going to testify. No, until 9:17 a.m. this morning, and I sent the email to all of the council, letting them know that this is going to be our witness today, and he is the only witness that we have today.
Okay, so theoretically, pursuant to my order, which I rescinded, you were going to call these substantial evidence witnesses today. So why can't you call those witnesses today?
So there was one substantial witness that we were calling today and one that we were calling tomorrow, because the one for tomorrow is not available today. The one that we were calling today, Ryan Sevier, we called his counsel back. We provided him a copy of your order to rescind, and he said, now this is a problem because my client wants me to be there, and I am unable to be there because I am on trial.
You didn't answer my question. Pursuant to my order, where I wanted to go forward on substantial evidence today, I said, prepare your witnesses. So presumably you prepared that witness. Why don't you call that witness today?
Because I understood from your order that you were rescinding it. And if we're calling this witness, and I think you just said it, we're calling the witness once. We're not going to call him for substantial value today and then call him for the rest of his testimony a week from today. So we let his counsel know, yes, this order's been rescinded. Please see the order. And we're going to question your counsel about everything. We're not going to just focus on substantial value. To which he replied, now we have a problem. My client wants me to be there. I can be there on Friday as originally scheduled.
Okay, well, as I said, that's one witness. How about the other 6 witnesses which we're going to testify today? Did you call them back up and say, look, the hearing officer made yet another blunder, and now I have to inconvenience you, so please come in today? They were planning to come in today. They get a message on Friday, you don't have to. You can call them on Tuesday and say, no, you have to come in. It's hard for me to believe that 7 people who you have lined up all of a sudden say, oh, in the last 48 hours, I made all these plans.
You only notified us in the last 24 hours that we needed to shift our focus from what you specifically ordered 5 days ago to focus on substantial value. And we're trying to catch up. So we've got one of our witnesses who was scheduled to come in today to come in as soon as he gets here. The other 2, we haven't had an opportunity to prep to testify because we canceled everything because you required us to present evidence specifically on substantial value.
Okay, once again, I did litigation for 30, if not 40 years. So, I understand the stresses you're under. And, candidly, I think you could have acted in another matter to have witnesses here today, but we'll get to that in a minute. So what are you going to do? I keep returning to this question. Well, first of all, let me make an order. I want you to provide today, the end of today, your witness list and when they're testifying to all the parties. Okay, that's number 1. Number 2, I want you to provide to listen to Mr. Bourgeois, and if we have to take a witness out of order, we'll take a witness out of order.
I just agreed to that.
Okay, well, we can continue taking witnesses out of order. So, to accommodate the parties. So I want you to speak with Mr. Bourgeois during a break today, and then report back to me. The 1 or 2 days testimony is going to be presented against his client where he has to be here, and it'll be at a mutually agreeable date. Is that okay?
Yes, sir.
Okay.
I believe we are speaking about one witness. Is that correct?
No, what I've said is that I need to know when you're going to call Mr. Keenan, and need to be here for him, and call Jeffrey Travers afterwards. I need a couple days advance notice so I can make the travel plans. But that's what I need. I need those 2 back to back, any order you want. And I need heads up of about 3 or 4 days so I can make the travel plans. That's all.
I'm going to ask everybody goes like this, but we if we resolve this, few weeks ago, we wouldn't have this problem today. So I'm just asking during the break, you and Mr. Bourgeois sit down and talk and reach it and just tell me what date. I don't care what date it is, but it's a date that's mutually agreeable to both of you.
We do not know what day Mr. Keenan is available,
Okay,
but
well,
we will make that information available to Mr. Bourgeois, and we will agree that both of them can testify on the same date. We're making that agreement here and now and on the record.
okay. Well, presumably you've spoken to Mr. Keenan prior to today and you've asked him that question. When Mr. Keenan can just give me,
It was
this
one
is
of the-
excuse me, these are the 9 trial dates we have. Mr. Keenan, what dates can you testify and what dates can't you testify? I'm assuming you had this conversation with him 3 months ago.
He was supposed to testify today. We were supposed to prep him on Monday. We didn't find out until yesterday that we were no longer focusing on substantial value.
Okay.
We actually did plan this out. We actually had a trial plan. So
As I said, you could have called, did you call Mr. Keenan yesterday and say, can you come in tomorrow?
Mr. Keenan is represented by counsel. I sent an email to counsel and asked, because we didn't have anyone for Friday, which of the witnesses were available to testify on Friday.
Okay, once again, do you know right now what days Keenan can testify other than,
We do not
and you
Because
never
we
asked him?
ask. No,
You never, okay.
no. What we did ask is we contacted counsel for the trial court. And we asked him, of the 4 court employees who are testifying, who's available on Friday, because we had no one on Friday.
Okay, as I said, I've been in your situation as a litigator, and candidly, I'm pretty unimpressed by the efforts you made. And I apologize for the inconvenience I caused you. I do apologize for that, but okay. So, we'll take a break at some time this morning. You folks will sit down. And as I said, I want you to give them a list of witnesses as soon as possible as to when they're testifying and what day they're testifying.
We modify the order. I should be as soon as possible, as opposed to close of business today. Something different earlier, and I want to make sure that we're as soon as possible.
Okay,
I'm not looking to move it earlier.
okay, at the close of business today, unless you come up with some roadblock, and then but you can give them a tentative list subject to last minute we got a problem, but give them the list today. They're entitled to it, to know who's testifying when. Okay, thank you. And it's for prepping witnesses. You're going to have the witness in here knowing, and then we could have been doing all this, and then Ms. Moran could have been downstairs prepping the witness for 2 hours, and we would have called another witness, and then you could have called your prep witness. So, okay. So
One last thing.
Yeah.
At least for me. I'm not sure what you can do for a sequestration order, but I would be looking for any of the witnesses, once we find out who they are, to be sequestered in terms of their testimony. And it's complicated, obviously, by the fact that there is access to the
internet.
proceedings.
Yeah.
So I don't know if you can fashion something to that effect.
So you want to set sequestration order for all the witnesses?
I think you have to, Judge. Yes.
That's your call. You want me to do it? I'll. So Ms. Kiley, do you want a sequestration order for the witnesses?
I want to prep the witnesses. And to prep the witnesses, including the ones I've identified. I have no position.
Hey, do you have a position on the sequestration?
I do not. Obviously, the parties have a right to be here and just. But as for witnesses, I don't have a strong position one way or the other. I think it's difficult with the video.
Yeah, Mr. Rusconi, you have a,
I don't take any position.
what's that?
I don't take any position.
Yeah, okay, so Ms. Work, let me just, what is the need to sequestrate? I understand it, it's a common motion. I understand that. So do you have the fear that, the witnesses are going to talk to each?
I can cut you off.
Okay.
We've had such a problem finding out who they're calling. Yeah, I would not like to have one of the witnesses here testifying when somebody else is sitting out in the gallery here, listening to the testimony.
Okay.
So that's obviously, it colors the content of their potential future testimony. So that's one of the things I'm concerned
Okay.
about.
Ordinarily, I'm very sympathetic. It's common motion, as we all know, but given the fact that just about every witness has made, statements that if they start coloring their testimony based on what they heard, and it seems to me that's a fertile ground of cross-examination, given what they've previously said. So, as I said, three of your co-counsel don't take a position on the sequestration. I just don't see a real problem with that. But if you're pressing me, it's a standard motion and it's standardly allowed. So,
Judge, given the fact that my counsel have not joined in this, I will withdraw.
Okay.
I'm not asking to be withdrawn. I just want to be able to communicate myself with the witnesses.
Yeah.
And if the witnesses are not going to be in listening to live testimony, I'm fine. That's
Okay.
a very appropriate motion.
Okay, so right now I'll just have a limited sequestration order by saying if a witness is testifying, another witness who's about to testify can't be in here. Is that acceptable for
Much
now?
appreciated. Thank you.
Okay, very good. Yeah, did you folks want to be heard? Okay, very good. Okay, so as far as the motion to vacate my order of consolidation, I'll just take that under advisement in the hope I want to deny it, and I'm hoping to deny it, and I'll deny it when the parties have an opportunity to meet today and discuss addressing what your concerns are. Okay, so hopefully at the end of today, you'll come and tell me I'm not going to see you until next Tuesday or tomorrow, whatever it's going to be. Okay, so okay, so is that it? Any other? Ms. Pruitt, do you have anything? Oh, Ms. McDonald, anything else you want to say? Nothing? Okay. Mr. Kiley, you have anything else?
Well, I'm just wondering, do we know what the witnesses for today will be available?
He's looking for parking.
Okay, and are there any other issues right now?
No, it's just how long we're going to break because of.
Okay, so he's just parking right now? Okay, so why don't I take, this is an opportune time to take a short recess. And then this will give you the opportunity to sit down with them and hopefully reach some type of accommodation and just report back to me on that. Okay, let's take just a short break and thank you all very much. So you don't have to rise anymore. I'm not a judge.
You're entitled.
Okay.
How long ago for?
You know what I'm going to do? I'm going to wait till the witness gets here, and then I'm going to give Mr. Boudoir an opportunity to speak, as well as you, because you have the right to know who that she's going to be calling. And then just give, who's she going to, has any progress been made? Where do we stand?
We have an agreement.
You do have an agreement. Oh, wonderful.
If you think I should put it in the record, it's fairly simple.
Go ahead.
The petitioner will inform me by tomorrow morning which of the blocks of remaining 3 days they intend to call Mr. Keenan. About 5 days before that, they'll tell me which specific day it's going to be so that I can make my travel plans.
Okay.
They do not plan to call Mr. Travers as part of their case, and so they will call Mr. Keenan on a Wednesday or Thursday to give me time to follow with Mr. Travers on my witness.
As I said, I could take witnesses out of order too, if need be, to accommodate all of the parties. For instance, if you have a party that's available one day and not another, and he's out of sequence or she's out of sequence, I'll listen to that person. So, okay, so where do we stand now? Oh, are we waiting for Mr. I apologize. Oh, I apologize. So where do we stand now?
Petitioner would like to make a brief opening.
Yeah, as I said,
Where we are?
yeah, guys, as I said, the parties are free to make an opening. I don't necessarily have to hear it, but if you wish to make one, I'll listen to what you have to say.
Candice Pruitt for the petitioner. This is a case about treatment. On October 16th, 2017, a woman crashed her vehicle into a concrete guardrail in a construction zone on Interstate 190 in Worcester. Her vehicle was blocking a travel lane. She was arrested for OUI alcohol and OUI drugs. During her arrest and thereafter, she made some statements to the arresting officer, some of which were explicitly sexual in nature, and she mentioned that her father was a judge. The police officer recorded the statements in his arrest report, and the woman's father was indeed a judge. Several things happened the next day on October 17th, 2017. Arrest report was the basis for a criminal complaint that was issued by the Worcester District Court. The statements made by the woman was the basis of a motion to impound the arrest report and complaint. The Chief Justice of the District Court decided to transfer the case out of Worcester County. Now, the evidence will show that after the case was impounded, Worcester District Attorney Joseph D. Early contacted the Colonel of the State Police, Richard McKeon, and advised Mr. McKeon that he could revise the arrest report even after Mr. McKeon stated that ship has sailed. State Police Colonel Richard McKeon ordered that the trooper revise the arrest report to remove the sexually explicit statements and that the trooper receive a negative evaluation. Anderson ordered that Mr. Sevier come to the barracks on his day off, told him what to remove from the arrest report, and then directed him to transport the revised arrest report to the Worcester County District Attorney's Office. And finally, First Assistant District Attorney Jeffrey Travers unsuccessfully attempted to substitute the revised arrest report for the one that was on file with the district court. All of this activity by high-ranking state officials about a misdemeanor for an OUI drug case. Now, the respondents have a myriad of excuses for why they took the actions that they did, just following orders. The rules of professional conduct required them to act. The statements would bring the state police in disrepute. This is not how we're fighting the opioid crisis. The statements didn't relate to probable cause. But the reason why these high-ranking officials took the actions that they did was because the woman was the daughter of a judge. And what you won't hear from anyone is why they would take action on an arrest report that was impounded on a case that was being transferred to another county. Petitioner filed orders to show cause against the respondents, Anderson, Early, McKeon, and Travers, alleging that they violated sections 23B2 and 23B3 by giving preferential treatment to the woman and or her father. And at the close of the evidence, we respectfully request that the commission hold that the respondents violated those sections and impose a civil penalty. Thank you.
Ms. Pruitt, thank you very much.
Yes.
Okay. Ms. Fierro, I see you getting up. I see.
Very good.
Thank you, Judge Meredith Fierro, on behalf of Respondent District Attorney Joseph Early. Petitioner's case can be summed up in 4 words: much ado about nothing. Nothing improper, nothing unethical, nothing unusual. Nothing other than the inadmissible, irrelevant, and salacious statements made by a confused, intoxicated, distraught young woman that should have never been in a police report. Here are the facts. A young woman in the throes of addiction drove into a guardrail and was arrested for operating under the influence of drugs and alcohol. The evidence against her was overwhelming. There were hypodermic needles in her car, she failed a breathalyzer, and she actually admitted to using drugs and heroin that day. She was, in the arresting officer's words, an absolute mess. She was crying hysterically. She was screaming that she was sick and an addict. And she was screaming and crying that her father was going to effing kill her because he was a judge. And she was falling in and out of consciousness during booking. But to make this heartbreaking situation worse, this new trooper wrote in a document filed with the court that this vulnerable young woman had made a reference to oral sex and included a quote attributed to her with the crude language that she used. So now this case has not only drugs and the defendant's relationship to a judge, but it also has sex, which is the trifecta for selling newspapers. And it is the prurient interest in this tragic young woman's statement, the illegal leaking of her arrest report, and the actions of a muckraking blogger that brought about the publicity that brings us here today. Now, you will hear testimony in this case that after reading the trooper's report, DA Early spoke with Colonel McKeon and Secretary of Public Safety, Dan Bennett, about the lewd statement. But DA Early told ADA Travers that the statement was prejudicial and that he eventually decided that the office should file a motion to redact. You will hear that in the meantime, Colonel McKeon ordered the report to be revised to remove the crude statements and issued observation reports to the new trooper and his supervisor as a teaching moment. He then called DA Early and told him that there would be a new report coming down. You will hear that DA Early sent ADA Travers to the clerk's office solely to determine what to do with the report, which led to lawful redactions being made. What was wrong about that? Should he have stood by and done nothing? Let a young woman suffering from opioid addiction be needlessly stigmatized and prejudiced by prejudicial pretrial publicity? DA Early did what he thought was right and proper as a prosecutor with ethical responsibilities regarding pretrial publicity and as a human being with insight into the personal suffering caused by the opioid crisis. You will hear evidence that DA Early has been an advocate for treatment for individuals with substance use disorder because he understands that it is a disease. He knew that the unfortunate but crude statements made by this young woman, if publicized, would only reinforce the public's archaic view that addiction is a moral failing, compromising her constitutional right to a fair trial. For that, he should be applauded, not condemned. The petitioner alleges that DA Early took two actions that violated the state ethics law. First, it alleges that he advised Colonel McKeon that the police report containing the crude statements regarding oral sex could be revised. But you will not hear testimony that DA Early gave any formal advice to Colonel McKeon. Instead, you will hear that DA Early informed Colonel McKeon that he was filing a motion to redact and that he made a comment that it wasn't too late to do something about the young woman's statement since it would never be allowed in court. There's nothing wrong there. The petitioner also alleges that DA Early directed ADA Travers to replace the arrest report filed with the court with a revised report. But you will not hear testimony that DA Early directed him to do anything with regard to the revised report other than to see the clerk. So there's no evidence to support the petitioner's allegations. Now, as you've heard, the order to show cause contains two charges against DA Early. The first charge is that he violated section 23B2 because he knowingly or with reason to know secured an unwarranted privilege for the young woman, which was of substantial value and not available to similarly situated individuals. Petitioner will not prove that the removal of the quoted statements from the police report was unwarranted. You will hear testimony that two judges independently ruled that the statements in the report were likely to cause pretrial publicity and should be shielded from the public, whether in the form of impoundment or redaction. So two judges ruled on this exact issue and agreed with DA Early's position. DA Early is the chief law enforcement officer for his district. He has broad discretion to determine how to proceed with the prosecution and what should be included in a factual statement to support probable cause. And as a prosecutor, he is required under Rule 3.6 and 3.8 of the Rules of Professional Responsibility to take steps to protect the accused from prejudicial pretrial publicity and ensure that she receives a fair trial. Petitioner also will not prove that removal of the statements was of substantial value, meaning worth $50 or more. You will not hear evidence establishing that removal of the prejudicial statements from an arrest report filed with the court has any monetary value whatsoever. Instead, petitioner will put on some PR guru to testify that he would charge at least $50 to help restore the young woman's reputation if the statements were made public. Take that evidence for what it's worth, which is nothing, especially because the report was impounded at the time that redactions were made. Lastly, the petitioner will not prove that DA Early's actions were unavailable to others who were similarly situated to the young woman. Petitioner will say that DA Early's actions were unavailable to others because this has never happened before. But that's exactly the point. DA Early had never before seen an arrest report containing such lewd statements when the accused wasn't being charged with prostitution. They were irrelevant to the OUI charge. They would be inadmissible at trial. Yet for some reason, the trooper felt the need to include such a salacious statement without regard to the needless shame it cast upon the young woman. The arrest report made clear that this young woman was suffering from opioid addiction. You will hear testimony that if such a report regarding any person with addiction came to the attention of DA Early, he would have done the same exact thing, and you won't hear any evidence to contradict it. The second charge against DA Early is that he knowingly or with reason to know acted in a manner which would cause a reasonable person with knowledge of the relevant circumstances to conclude that he was unduly influenced by the young woman or her father, or that he is likely to act or fail to act as a result of rank or position. You will hear testimony regarding a number of circumstances that dispel those allegations. For example, you will learn that when DA Early first learned from ADA Travers about the arrest of the young woman and who she was, all he did was responded, "Thank you." And he didn't take any action with regard to the case until he read those crude statements in the arrest report. You will hear testimony that as a former defense attorney, DA Early was especially sensitive to the issue of prejudicial pretrial publicity. And you will learn that the policy of his office was that complaint application should be supported by a concise statement of facts rather than attaching an entire police report. And again, you will learn that two judges separately ruled that the statements presented a risk of prejudicial pretrial publicity, which alone should dispose of this case. And you will hear testimony that DA Early believed that it was his ethical responsibility to protect against prejudicial pretrial publicity and that those suffering from opioid addiction should not be stigmatized. Now, petitioner has said today that this case is not about opioid addiction, but please take note of what the recipient witnesses have to say. You will learn that in the 4 days that these events took place, DA Early spoke with Colonel McKeon about how policing has evolved to treat individuals suffering from addiction with compassion, that he spoke with Judge Dolly about the suffering caused by addiction and about his visit to a women's detox center in Essex, that he spoke with Judge Despotopoulos about attending a meeting with legislators about setting aside a block of cells at a jail for inmates in recovery. And you will hear that he understood the all too frequent connection between addiction and sex trafficking. I submit that if a reasonable person knew these facts that give context to the stories about this case, not on the internet or in the newspaper, they would not conclude that DA Early violated Section 23B3. There's one other thing that I ask you to keep in mind while you hear the evidence. The events in this case unfolded in a matter of days. These are human beings who are making quick decisions in a high pressure situation. And you will hear testimony that may reveal some disorganization or lack of clear communication between the DA's office, the state police, and the judiciary. For example, you'll hear that the arresting officer initially didn't even know where to deliver the revised report, and a trooper had to contact the clerk's office, which then contacted the DA's office to figure out where to bring the report. And you will hear that DA Early got a call that a revised report was coming, but he didn't know what it said or what he should do with it. This was not some grand conspiracy, just honest, dedicated, hardworking public officials trying to do the best they can. A wise mentor once told me that after I perform any task, I should look back and ask, what should I have done better? What can I learn? Are there things that could have been done better by everyone in this case? Of course. But as you hear the evidence, I respectfully ask you to keep in mind that it's easy to Monday morning quarterback. It's not DA Early's burden to prove that he did the right thing for the right reasons, although he most certainly did. It is petitioner's burden to present credible evidence to prove that DA Early violated the statute. I submit that at the end of the evidence, you will find that there is none. Thank you.
Okay, thank you very much, Ms. Fierro. Mr. Burke?
Chairman, thank you. This is Attorney Tim Burke representing Susan Anderson, who at the time was a major in the state police. And I think it's important to point out that she has been one of only, I think, 5 women in the state police to ever reach the rank of major. She is an accomplished, very qualified and committed member of the state police. And it's important to also point out, Your Honor, that as you know, this is a paramilitary organization. They are responsible for following orders, and this was determined to be a lawful order that was given to her. To put this into context, you've heard and you know as much as anybody does about this case, but I think it's important for the public to have a different view than what's been presented to it by the media. And this has been a media-driven case, if you will. The accident happens, she's arrested. There was clearly probable cause to arrest her for OUI. She was never charged, the judge's daughter was never charged with OUI. I'm sorry, she's never charged with solicitation or any kind of sex-related offenses. But I know you have, if you look at this police report and you see in seriatim how the field sobriety tests are conducted, the 3 separate tests, beginning with a nystagmus gaze test, the 1 step, the walk and turn. All of that demonstrates that at the time of the arrest of Ms. Bebo, there was clearly established probable cause by her own admissions and the statements that she made at the time that she was there at this accident scene. It isn't until probable cause is established and she's placed in the cruiser, other salacious statements are made and then put into their police report. And I'm going to ask you to take particular attention to the timing of this. You'll notice that the time of the accident is roughly a dispatch to it was 7:35 in the afternoon on October 16th. And Miss Bebo was released, I believe, around either 10:17 or 10:47 that evening, a period of 4 hours, roughly 3 hours. But I'm going to ask you to also take a look at the time of the arrival of the bail commissioner, time that bail was set, and when she was released. And also play into particular attention as to when the police report was drafted and submitted, because you're going to hear testimony about the interaction between the bail commissioner and Trooper Sevier, that he had a tiff with her about the manner in which the bail was actually posted. And that's going to be important in terms of after the prisoner is released, his report isn't finished until right around 1 o'clock, 2 o'clock in the morning. So if you will, I suggest to you that the evidence is going to show that tiff created an animosity or an attitude that engendered the entry of these salacious statements into the police report. It did not contribute to probable cause. They had nothing to do with the actual arrest. And what's important to distinguish for my client is that this incident happens on October 16th, 2017. She's on vacation. And I am not critical of any decision that was made by Joe Early or by Colonel McKeon. Frankly, I agree with them. But my client is in a different position. She did not participate in those discussions in anything whatsoever. She's on vacation. She doesn't come back until October 19th. And what's most important here, my client, Joe Early, or Colonel McKeon played any role in making the decision to impound this police report. It's important to point out that the defense attorney, the court-appointed defense attorney, who was there for her arraignment, for Ms. Bebo's arraignment, the following morning, October 17th, gets the report, reviews the content of it, immediately realizes what everybody should understand, that it has content in it that doesn't go to probable cause, that's not relevant other than just for the purpose of ostracizing somebody who is a very vulnerable human being. That motion to impound was filed by the defense attorney, not by anybody else, and clearly not by my client. My client doesn't come back. And actually, if you just follow through that, just like we're here today, that motion to impound was conducted in open court with a public record, with anybody's participation who wanted to be there. Again, the judge, an independent judge, made the determination, yes, the content of that police report is problematic. It elements in it and statements that have nothing to do with the probable cause that existed already. And he impounded it. And it's one of those things where what are they supposed to do with that then at that juncture? They did what that was appropriate. They did not change probable cause criteria. They did not change any of the actual charges. They did not make it harder for anybody to prosecute the case. They simply looked at the content, what was salacious, what was inappropriate, which had nothing to do other than he tried to be salacious for the purpose of whatever that was in the mind of the arresting trooper. Those documents is when those statements is when my client is given an order by her direct supervisor to have that reviewed and have those statements removed, and only those statements. And it wasn't done under the darkness of a 5-watt light bulb. It's done in open. They brought the trooper in. They made the statements to change that should not have been in there, put on the top of it, revised the date of its revision, and then brought it to the district attorney's office, who then brought it back before a second judge for the purpose of having those redactions made in open court. My client had an obligation to follow the directions that she did. She did so because it's a paramilitary organization. And I'd ask this court, the commission, at the time of this is concluded, to render a judgment in her favor in good conscience and good faith. The evidence does not support that there was any interrelationship or prior knowledge or relationship with my client, Judge Bebo, or her daughter. He never had met either one of them. There's nothing here that demonstrates that she was motivated in any other way other than to do what was appropriate in accordance with what her directions and orders that were given to her. Thank you.
Thank you very much, Mr. Burke. Ms. Rusconi or Ms. Bourgeois, you plan to make opening statements? And okay. Entirely up to you.
Thank you, Commissioner Cantwell. The good news is I'll be brief. The undisputed fact, as my brother just pointed out, is that before any of the respondents acted, before anyone did anything, independent district court judge had looked at the probable cause statement and arrest report and decided that the words in that report threatened the defendant's right to a fair trial. He then took the step of impounding the entirety of both of those documents. That is a reality that petitioner has to accept in this case, that everybody acted in the face of a judicial determination that what was in that report threatened the right to a fair trial. What happened, Mr. Travers had no involvement in any of the discussions with the state police. He had no involvement with anything until there came into his possession a revised report. Petitioner says Mr. Travers should have done nothing with that report. He should have sat on it, and he should have allowed the total impoundment to continue. Now let's think. A judge's daughter has been arrested. The entirety of the documents have been totally impounded, and there comes into his possession a document that removes the offending language and would eliminate the impoundment. And at the end of the day, the undisputed evidence will be that is what Jeffrey Travers accomplished. Petitioner doesn't like it, but there is more public information available at the end of the day than there was at the beginning. Prosecutors are charged with what our Supreme Court and our Supreme Judicial Court have said is an affirmative duty to take steps to secure a witness's right to a defendant's right to a fair trial. Affirmative duty means exactly that. You take steps to do it. In this case, the only thing my client did was to both preserve the right to fair trial and to create public access to the balance of the arrest report. That is not favoritism. Doing nothing, which would have kept the report completely impounded, might well have been caused favoritism. There was no value for a report that was being impounded, being revised and made public. And there was nothing especial done because of this person being a judge's daughter, except that it was the fact of the judge's, or being a judge's daughter, that created the risk of publicity in the first place. That's what I expect the evidence to prove, and I expect at the end that the commissioner will discharge Mr. Travers without any responsibility for violation of these statutes. Thank you.
Oh, thank you. Mr. Rasconi, you have anything you want to say?
Thank you, Your Honor. Your Honor, I'll be as brief as I can because, quite frankly, most of the points that I would have made otherwise have been made by Attorney Fierro, by Attorney Burke, and by Attorney Bourgeois. I will say with respect to Colonel McKeon, he simply had something dropped in his lap. He could have done two things. He could have done nothing, or he could have done something about it. How it got there really is no concern. It's there. It's a situation he has to deal with now. And he chose to act in a way which he felt would reflect positively on the Massachusetts State Police. You're going to hear testimony from him that he, as the colonel of the state police, was on a board overseen by the Department of Public Health. That board contained a judge. That board contained some attorneys, chiefs of police. It contained some people that were in recovery. It contained people that were parents of children that had passed away. So before all this happened, he's very sensitive to the opioid crisis in Massachusetts, as I'm sure we all are now. In 2014, through this department he was in, he helped secure naloxone, otherwise known as Narcan, to be provided to the state police. So this is an issue that is already on his radar. You're going to hear testimony that in troop command meetings, specifically one on September 26th, 2017, just before this event happened, he raised the issue about shoddy supervision in his department. There were things that were getting by supervisors that he thought were sloppy. There are certain protocols they have to alert the colonel and other high-ranking members of sensitive issues. One of those issues was a Lynn police officer that was arrested that he was not made aware of, and he was blindsided by it. And I'm sure there'll be other examples that he'll provide to that effect. Obviously, the daughter of a member of the judiciary, or quite frankly, law enforcement or the clerk's office or any part of the criminal justice system, is sensitive because it will be brought to him at some point. So it is something that he's going to pay attention to. So once he's provided with this information, he heard this language in the report as relayed by DA Early, it didn't sit well with him. He thought that it cast the department in some disrepute, and he decided that under his authority, under GL 22C, Section 3, that gives him pretty broad powers to direct police investigations, how police reports are written, how, generally speaking, the department is run. That's his authority. That's statutory authority provided by the legislator. And he exercised that authority. He issued an observation report to the trooper. An observation report has been some point of contention throughout this process. Is alleged by the trooper making the arrest that it's a disciplinary action. That trooper is the only person in any of the evidence you're going to hear, whether in state police or otherwise, that it's a disciplinary action, and that's because it's not a disciplinary action. Downey v. Johnson is a superior court case that explicitly states that it's not a disciplinary action. It is a way to educate a young trooper who's been on the force for just over a year, maybe under 2 years, that, listen, this is a salacious statement. It's inappropriate. And again, the reasons it were inappropriate have been brought up by co-counsel. So I don't think I need to get into that. I don't need to get into the probable cause and what needs to be included in the arrest report. The bottom line is The observation report was succinct. It was a very easy way to educate the trooper without disciplining him, saying, this is a salacious statement that doesn't relate to probable cause. Please don't do it again. It wasn't done behind closed doors. It's not cloak and dagger. It's done to educate the young trooper and to let everybody know this isn't just for this particular person in this particular situation. This is for everybody. If you see something like this again, please use some discretion. Don't put that in a report if it doesn't need to be there. So again, in a nutshell, this is a good faith effort by the colonel to exercise his authority granted by the legislator to run his department in the way he sees fit. The way he saw fit to run the department is to reduce stigmatization for people that are suffering from substance abuse and addiction, and to protect a young trooper from walking into a courtroom sometime later on in the future and having colleagues, other people whose opinions that the colonel respects in the system, in the criminal justice system, wonder, like, what's Colonel McKeon doing letting his troopers put the stuff in a report? And quite frankly, you hear from Colonel McKeon, it wasn't necessarily Trooper Sevier himself, it was the supervision. The supervision to him was paramount, and he felt supervision should have played a more active role in this case. The supervising trooper also was issued an observation report. There are avenues to appeal the observation report if the recipient feels aggrieved. Neither of those recipients of the observation report exercised that avenue. So at the end of the day, again, I don't want to belabor the substantial value, the unwarranted privileges and things of that nature, because quite frankly, we've heard a lot about it, and you're going to hear a lot more about that from me during the closing, I assure you of that. But Colonel McKeon was acting appropriately every step of the way. He was acting appropriately pursuant to his powers granted by the legislator, and he is trying to direct his department to act in a way that he sees professional, that he wants to have respect garnered throughout the legal community and the community in general. So for those reasons, at the end, I'm sure you're going to hear from me during the closing that I'm going to be asking you to find in the negative against the petitioner.
I appreciate the argument. Ms. Kiley?
Given Mr. Rusconi's reference to the statute, I'm going to ask you to take administrative notice of General Laws, Chapter 22C3, which Mr. Rusconi referenced. And in particular, with respect to training, I'm going to ask you to take administrative notice Section 10 and Chapter 22C, Section 20, which bestows specific powers on training with respect to training.
Okay, I appreciate that.
Thank
Fine
you.
argument by all five of you, so I appreciate your arguments of all of you. Fine job. I'll note it's 10-1, so just let me get a roadmap of where we're going, and I'm going to ask the parties what they want me to do. Ms. Pruitt, what do you have to say?
We can take the lunch break.
Okay, and it's your preference to take a lunch break, but I just want to know, how many witnesses do you have?
One.
Okay, how long is that witness going to take?
Shouldn't take long.
When lawyers tell me that, I always mind.
It's
It
always
always
tough
goes
before
up.
cross-examinations. I mean, our portion of it should not take long, the direct examination.
Okay, so you want to take a lunch break, which I think is reasonable, but Ms. Kiley, what's your preference?
I'm indifferent. I will do some cross-examination, and I am always longer than I intend to be.
Okay, Ms. Burke, what's your preference?
Just here to please, Judge.
What's that?
I'm just here to please.
You're not
Whatever
helping me
works.
out here, okay? Yeah, Ms. Bourgeois, did you want to take a lunch break?
If it's going to be a longer direct examination, I think we probably should take a lunch.
Yeah, I think we should too. Okay, Ms. Rusconi, I don't want you last but not least, but.
If I stand up and say I don't want to take a lunch break, how's that going to go?
Okay, my next question, because, I'm very sensitive to the time, you're all very busy, and I'm very sensitive to that. So how long of a lunch break? Ordinarily the trial would be an hour, but, there's a cafeteria downstairs. We can take the hour if you want, or make it 45 minutes. What's your preference?
45 minutes, please, for the petition.
45 minutes you would like, Mr.
I'm indifferent.
You still want to please the court, whatever.
Whatever you say.
Okay, yeah, you too. Ms. Bourgeois, do you have a preference as to the length of?
I do not, sir.
Yeah, Mr. Rusconi. Okay, so I'll adopt Mr. McDonald's, Attorney McDonald's. So we'll take a 45-minute break, so we'll be back here about 1:35, 1:40 or so. Okay, so have a good lunch and we'll see you folks soon. On the break, just right before I came on, Attorney Bourgeois had wanted to say something. Ms. Bourgeois, what do you have to say, sir?
Yes, sir, just as a procedural suggestion or understanding, we would agree that the objection of any one respondent's counsel is sufficient to preserve the rights of all respondents' counsel to address a particular point or issue. That way there, we don't have to have the court reporter keep track of 4 different lawyers who are objecting.
That's fine. That's fine. So just for scheduling purposes for the rest of this week. So how many witnesses do you anticipate having tomorrow?
1,
Just one?
just 1.
You can't get another witness?
No,
I don't quite understand what the problem is.
We off the record still or not?
No.
We're on the record, so, well, but does anyone want to? Because on Friday is Good Friday and it's Passover and Easter and it's a long weekend. So
and we
can't,
have 2 witnesses on Friday.
so what I would like to do is end like by 3:00, if that's agreeable with the parties. Is that okay? And it no later than 3. So, so is there any possibility you can get another witness for tomorrow? I just don't quite understand the problem with getting witnesses here.
We will speak with the attorney for the trial court to see if we can get another witness for tomorrow.
Okay, I'm
We'll speak with the attorney for the assistant district attorneys who are scheduled for next week and see if one of them can appear tomorrow.
Excuse me, my apologies for
No,
crossing over.
quite all right. We just doing some administrative things.
Judge, if you're looking for someone to voice an objection, let me be the first.
Yeah.
I mean, this is ridiculous.
Yeah,
I mean, we've had 4 years. And it goes back to what I've been harping on. We needed a specific time and place for each of these witnesses. And it's inexcusable that we're held captive here because one of the witnesses needs his attorney here.
I agree with you. So,
Does he want to take the 5th? I mean, there's no other reason for an attorney to be present unless his client is going to incriminate himself.
well, you have a good point. What do you want to say, Ms. Pruitt?
Yeah, if I may, witnesses have the right to be represented by counsel. This in this proceeding. I can't imagine that any attorney would advocate for a witness being deprived of their right to their counsel of their choice. We had a lineup, we had a process in place, and that was all upended. So here's where we find ourselves now, scrambling to try and get witnesses for this hearing. And we were lucky to get someone today. We have someone tomorrow. We have 2 people on Friday.
Okay, well, you're gonna have to scramble harder. And you're gonna have to get a witness in tomorrow, and then one of your co-counsel can deal with the witness. And if you don't have more than 2 witnesses tomorrow, and if we're not going to 5:00, I'm gonna entertain motions for sanctions. Anybody else want to be heard? Okay, so call your first witness.
Good afternoon, presiding officer Kantrowitz. Good afternoon, Commissioner Edwards. John McDonald for the petitioner. Petitioner calls Jamie McKeon.
Okay, I'll give you another one.
Well, thank you. City Trooper, can you stand up, please? Do you solemnly promise and affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth in these proceedings before the State Ethics Commission?
I do so.
Okay, thank you, sir.
Yes, sir.
Thank you.
Sure.
And so I didn't injure you.
Inquire, presiding officer Kantrowitz.
Please.
Thank you. Please state your name for the record.
Jamie, Jamie, middle initial J, last name McGarian, Magarian.
Are you appearing here today because you were subpoenaed?
Yes, sir.
Could you describe your education after high school?
I went to Westfield State College, my undergraduate degree in liberal arts. In 1997, I proceeded on to my master's degree at Western New England College.
Can I just interrupt you for 1 second? Madam Court Reporter, are you having some, because his back is to you?
Yes, I would prefer if he could turn just a little bit to his
Okay,
left.
yeah, okay, so is that better?
That's much better, thank
Okay,
you.
okay, thank you.
Thank you. Did that finish a description of your education after high school?
I went to Westfield State College, received the degree, bachelor's degree in liberal arts, then proceeded on to Western New England College and received the degree in criminal justice administration, my master's degree.
And what year was that?
I believe 97.
Are you currently employed?
I am, sir.
Where are you currently employed?
I'm currently employed by Municipal Police Training Committee as a statewide standardized field sobriety instructor and chemical breath test instructor, as well as a staff instructor.
And where is the Municipal Police Training Committee located?
Headquarters is in Randolph, Massachusetts.
And what's your position with the Municipal Police Training Committee?
I'm the statewide coordinator for standardized field sobriety, chemical breath testing, as well as an instructor at local municipal academies across the Commonwealth.
Working at the Municipal Police Training Committee, were you employed?
I was
Where were you employed?
from November 2004 until December 11th, 2018 for the Commonwealth of Massachusetts Department of the State Police. Prior to that, from April 1st, 1996 until October 31st, 2004 for the Town of Amherst, Massachusetts Police Department. And from January of 1993 until March of 1996 for the Gaston County Police Department in Gastonia, North Carolina.
So how many years total is that in law enforcement, Mr. McGarry?
Approximately 26, sir.
In your law enforcement career, approximately how many arrests have you made?
1,500, 2,000, in the thousands, sir.
And approximately how many arrest reports have you written?
Roughly around that same number, 1,500 or so, 2,000.
And in your law enforcement career, have you ever reviewed arrest reports written by other members of law enforcement?
I have.
Describe the circumstances that you would review those arrest reports.
I reviewed arrest reports within my own barracks. I reviewed arrest reports of my colleagues within the State Police Detective Unit in the Northwestern DA's office. I reviewed arrest reports for district attorney's offices from Boston to the Berkshires for OUI cases, mostly involving OUI serious personal injury or OUI related fatalities.
Have you provided training about writing arrest reports?
I have.
Where did you provide training about writing arrest reports?
Both at municipal police academies as well as the state police academy.
And is that the Massachusetts State Police Academy?
Yes.
And who did you provide training to at the Massachusetts State Police Academy?
The 80th Recruit Training Troop, the 81st Recruit Training Troop, part of the 82nd Recruit Training Troop. I believe it was the 85th Recruit Training Troop because it was just when COVID, winter of 2020, kind of got changed around because of COVID.
And where would you provide that training, Mr. McGarry?
On the academy grounds in New Braintree, Massachusetts.
And could you describe how you conducted the training?
Sure, it was in a classroom setting, PowerPoint, lecture, handouts, copies of police reports from other state police officers, municipal officers, myself, practical exercises of giving them a fact pattern and having them write a report, practical exercises of them being out in applied patrol procedures and case scenarios in which they would write a report on what they saw, what they did, what they saw, what they heard, witness statements. They would formulate those reports based on a training scenario, and I would review those as well.
All right. Presiding Reverend Kandrowicz, may I have from the legal advisor what has been marked as petitioner's disputed exhibit 12, please? petitioner's disputed exhibit number 12.
On that one.
Thank you. It's a bit heavy.
Has this been admitted into evidence already?
This is in the disputed exhibit folder, Commissioner,
It's disputed.
disputed. We were not unable to reach a stipulation on this item.
Ms. Kylie, well,
Is this the item that was referred to as 6 earlier today?
The PowerPoint.
The PowerPoint
Okay.
presentation, I don't know, I don't remember what was referred to earlier, but.
The
We
PowerPoint.
talked about it today.
Yes,
There still is an objection, but we reserved until this witness was on the stand.
is the procedure, I'm sorry, President Arcandowitz, that you, the legal advisor, give the document to the witness for his review?
so this is what I'm being handed. It's
Yes.
exhibit number what, 6, you say?
It should be petitioner's disputed exhibit number 12.
Number 12.
Yes.
I was off. And it's entitled Report Writing Trooper.
Right, it's a PowerPoint presentation.
2867. Okay, that's the
Yes, I'd
document.
ask that Mr. McGarren.
I'm sorry.
Thank you for giving that document, thank you. Mr. McGarren, if you could look through that PowerPoint and just please look up when you have a chance to complete your review of it.
This is. Yeah.
Did you have a chance to review that document that's been marked as petitioner's disputed exhibit 12, Mr. McGarren?
Yes, sir,
Do you recognize that document?
I do.
What do you recognize that document as?
I report, this is a PowerPoint for report writing I used at the Massachusetts State Police Academy.
Okay, and how do you recognize the document as such?
I published the majority of this document.
Why does it say Trooper Mark Hannon on the covering sheet?
He most likely taught the report writing after I stopped teaching it and used my material.
So who wrote that document that's in your hand right now?
I would say me, because there's PowerPoint presentations in here from the Amherst Police Department that I would only have access to when this document was created years before I got to the state police.
And that's because you were previously employed by the Amherst Police Department, is that correct?
Yes, sir.
And was this PowerPoint something that you used when you trained the recruits at the Massachusetts State Police Academy?
Yes, sir.
Presiding Officer Kanzowitz, at this point, I'd move to admit this document as an exhibit in the adjudicatory proceeding, please.
I think if you object to that? I do. Okay, you know what, I'll defer until I hear, the cross-examination, any objections, okay? Thank you. You want to hold on to that?
Maybe if I just have him hold on to that for now, I might have some questions about it. Okay, thank you. Mr. McGarren, why is training about writing arrest reports important?
It becomes a legal document of your actions, your observations, what you heard, what you saw, what you learned from others, witnesses, et cetera, for prosecution of that case if it goes to trial.
Describe what training you provided to the Massachusetts State Police Academy recruits about writing arrest reports.
Objection. May be heard. I want to know, when we're talking about, we have a series of academies, series of troops. I'd like to be able to place it in time.
Just why don't you just elicit that information?
When would you have provided training on writing arrest reports to members of the Massachusetts State Police Academy?
So it would have
The
been
period of time being.
the 80th Recruit Training Troop, which the years escape me, would have been the 80, it's on my resume. The 81st Recruit Training Troop, part of the 82nd Recruit Training Troop, and part of the 85th Recruit Training Troop. So I want to say 2011 through 2014, and then the 85th, I believe, was in 2019 into 2020.
Is your memory exhausted on when exactly you provided the training to the recruit training
Yes,
academy? Is there anything that would refresh your recollection as to when you provided the training?
probably my resume, sir.
Could I approach the witness to hand him a copy of his CV?
Did the other parties have copies of this?
I believe they do, yes.
Yes, and I provided it to Mr. Shaw and I gave copies to everybody else.
Okay, great. Thank you.
Sure.
Thank you, sir.
Well, can you just review that document, please?
Just for the record, what is the document he's reviewing?
It's a CV for Jamie McGarry.
Okay.
Get a chance to review that CV, Mr. McGarry?
Yes.
Does that refresh your recollection about when you provided the training to the members of the recruit training troops?
Yes.
The police committee, and when did you provide that training?
So 2010, 2011, 2012, part of 2013, and then 2019 into 2020.
During those years you just testified to, describe the training you provided to the recruit training troops at the State Police Academy relative to writing arrest reports.
It would have been under a report writing class. But
What are some of the things that you instructed them about?
Just all the situations, there's several types of reports. Just all the situations where you would document your actions or your observations, or anytime your senses kick in, essentially establishes probable cause. We also discussed writing police reports in OUI cases because I taught standardized field sobriety. I also taught operating under the influence of drugs, so we talked about reporting reports then. A myriad of different circumstances. So.
And what are some things that you told the recruits that was important to include in arrest reports?
Well, naturally, most crimes, since I've never done it, I don't believe anybody has, since we don't really investigate crimes of specific intent. By that I mean when we know something's going to happen and don't kind of intercept that. Most of the events are based on secondhand knowledge for witnesses before you get to a scene of a crime. It's important, again, to document what you've learned from others, witnesses, fellow police officers, other people on the scene, what you do, what you observed, what you heard, right through from your initial response to information about being dispatched, the weather, where you're going, who dispatched you, what you see when you get there, right up through the continuation of a booking process and submittal of that document to the court officer at the barracks. Again,
What specifically, what type of training did you provide to recruits about recording what a suspect said at the scene?
Objection,
What's the objection?
leading question.
That's a,
Did you need to repeat the question?
yeah,
Can I just have the court reporter read back, please?
Question specifically, what type of training did you provide to recruits about recording what a suspect said at the scene?
recruits were instructed to provide, reiterate witness statements that they overheard directly in direct quotations in their police report.
And
can we get a clarification as to the year that he was making these? Was it during the entire period that he alluded to before?
I'm sorry, could you rephrase that, Commissioner Candace?
You know, you elicited what he teaches students, and I'm just
Yes,
curious as to the years that
Okay.
he was teaching students, because that seems to be an issue here.
I understand, thank you.
Okay.
Would that training generally have been consistent throughout all the trainings that you trained the recruit training troops at the Massachusetts State Police Academy? Is that a general principle you would have emphasized to all the recruit training troops?
Yes, it's in this PowerPoint, and this is my guide to training.
So that's something that you would typically give at any training class that you provided to recruits, is that right?
Your Honor, may we just not have him lead the witness? This is like the third question in a row of this.
What's that?
Could you ask him to not lead the witness? This is like the third question he's asked which clearly indicates the answer he's trying to elicit.
I realize that, but I'm going to give him a little leeway on this. So, but continue to object if you feel that it is appropriate. But
Did you need the court reporter to read that last question back? Okay.
The answer to that is yes. Again, it's in here and this is what guided me through those trainings.
So again, why is quoting exact words that a suspect states important? Why is that important?
Objection calls for an opinion. This is not an expert witness, not qualified as such with the requirements of the rule.
I'll try to rephrase the question if I could.
no,
Okay.
the number one, you never try to snatch defeat from the judge. Number one rules, that's overruled.
Thank
So
you.
we can thank you.
Did you need the court reporter to read the question back?
Yes, please.
Thank you.
Question. Okay, so again, why is quoting exact words that a suspect states important? Why is that important?
It's important because it's what you're learning, it's what they're saying, it's their knowledge that you may not have at the time that may come out as an utterance or a statement, something that may be inculpatory or sometimes exculpatory in relation to the crime itself.
All right, I asked that Mr. McKeon be shown stipulated Exhibit 1, please.
Do you need this?
No, it's the smaller book. Yes,
No, I don't.
excuse me.
Yeah, bigger table. Yeah.
We do
So
need a bigger table.
be careful, please.
Thank you.
Be careful stepping up.
My apologies, the stenographer marked them this morning and I forgot to retrieve it
No,
from
no.
her.
No apologies necessary. This is what exhibit?
This is stipulated Exhibit number 1, please.
Thank you.
Thank you, sir.
Thank you.
Mr. McKeon, I just asked you to take a look at that document, please, and look up when you're done.
While he's doing that, just for the record, can we be crystal clear? What is it that exhibit
This
is?
is the original arrest report of Ali Bebo.
Thank you.
It is what it is. It's been labeled that. Object to the characterization.
Okay, well, we know what it is, so,
You know what it is.
okay,
Mr.
thank you.
McKeon, did you get a chance to look at that document?
Yes,
And do you recognize that document?
I do, sir.
And what do you recognize that document as?
It's an arrest report of Ali Bebo from October 16th, 2017, approximately 1940 hours out of C6, which is the State Police Holding Barracks.
And I direct your attention to numbered paragraph 9 of the police report, if you could please take a look at that numbered paragraph.
Yes, sir.
If you could read that numbered paragraph and please look up when you're done.
Yes, sir.
Do you see some language in that paragraph about certain sexual acts performed in exchange for drugs?
Yes, sir.
Have you seen similar language included in other arrest reports?
Objection.
Uh, Yeah, I'm not sure, I'm not quite sure of the relevance, but I'll allow it.
I've seen explicit language like that in several police reports, some of which I published myself.
Now, why would language like that be important to be included in an arrest report?
Objection.
You know, it's kind of hard to say. I'm giving you a certain leeway here, but which I'll continue to do for a short while, but the leash is starting to grow shorter because every case is radically different. So what he wrote, 10 years ago, times change. So, but leash is getting short.
Okay.
Can I?
Oh, sure, Mr. Yeah.
This is not simply, compared, this is not apples to apples. He said he's wrote similar language in other cases. It's not an OUI with a judge's daughter if we have comparators that we're gonna use, they should be on point. And I don't think just saying, yeah, I've seen this before, I've done it before, it has relevance here unless it's specific to the criteria that's in this report.
No, I fully understand that, and I fully expect you on cross-examination to question him on that. Okay?
Do you need the court reporter to read back that last question?
Yes, please. Sorry, ma'am.
Question, and why would language like that be important to be included in an arrest report?
Again, it's a statement from a person of interest or, the suspect in a crime. If they say something you believe may be applicable to the crime itself or have relevance, then you would include it in your police report.
And would including that language in the arrest report be consistent with the training that you provided to recruit training troops at the Massachusetts State Police Academy?
Yes.
And how would it be consistent with that training that you provided to the recruits?
Review that PowerPoint. They're directed to use direct quotes for people who make utterances or statements, either prior to arrest or during arrest. A statement that's not a response that you had elicited from them, or a statement maybe that's made either after Miranda, if you're in custody, to put those things in direct quotes if you think it's important to the crime itself.
How are arrest reports processed by the state police?
A trooper or supervisor, whoever's writing the arrest report, would document their actions on that evening. You would then submit that report electronically after making a phone call to the duty lieutenant, or if there was a patrol supervisor available, you'd call them and say, hey, I finished my report. Would somebody please review it and approve it, in which they would. Once it was approved by usually a sergeant or then a lieutenant, you would print out all the copies that were needed for court. You would put it in a packet to include anything else, copies of citations, if there's a separate witness statement, anything like that would go into a packet. That would get put in a box for the court officer. That court officer on the following first day is sitting on the court. So if it was a Friday night, it would be Monday morning. They would go to the clerk's office with that documentation that you had memorialized.
So who writes the arrest report initially?
The investigating or arresting officer.
Okay, and who would review the arrest report that the arresting or investigating officer or trooper wrote?
First line supervisor being a patrol sergeant. If they weren't available, it would be one of the lieutenants, either a lieutenant at the barracks or a duty lieutenant at the headquarters for that troop.
Describe when a major would review an arrest report.
Objection, Judge, under what circumstances?
So, and that's overruled. Yeah.
I've never had that happen. I don't know of any circumstance where that has happened. The direct approval, even when I was in the state police detective unit for major crimes, would still be from my detective lieutenant and somebody at the Northwestern District Attorney's Office. Certainly there are reports in the state police detective units where the command staff likes to be aware of any major incident, bank robbery, sexual assault, any homicide, any unattended death. And those are just little probable cause statements that we would prepare from the morning briefing for the state police command staff in Framingham.
Describe when the colonel of Massachusetts State Police would review an arrest report.
Objection.
Yeah, it's, okay, that's overruled.
I don't know. I've never had that occur.
To your knowledge, what's the process for changing an arrest report that has been approved?
My process and how I've instructed other people to say police academy, that if there's something needs to be corrected in an approved report, and I've done this myself, you notify the district attorney who has the case that you have a supplemental report that you're writing. That would then be approved by your immediate supervisor. Then that would be forwarded to the court officer to be submitted to the DA in charge of the case itself.
Have you ever seen an arrest report changed after it was approved?
I have not.
So you talked a little bit earlier, but what happens once the arrest report is approved? What's the next step in the process?
The court officer would bring that documentation to the courthouse.
And is the court officer, is that a trooper?
Yes.
And
They would meet with a clerk. The clerk would read the report, stamp time and date, stamp the report, and then distribute those copies for discovery for the prosecution, for the defense, for probation, or wherever they need to go.
what would be the process for changing an arrest report after it had been submitted to the court?
I don't know.
Objection.
He said doesn't know.
Have you ever seen an arrest report changed after it was submitted to the court?
Objection.
That's not the rule.
No.
May I have a moment?
Sure. Those are my copies. Oh, okay. Thank you. Thank you.
Thank you. Mr. McKeon, how did you first learn you were going to be a witness in this proceeding?
I received a phone call, sir.
Who did you receive a phone call from?
My brother, Jay McGarren, who's a Worcester police detective.
And what did your brother tell you?
Objection.
This is hearsay. I'm assuming you're using it for a non-hearsay purpose.
That's correct.
Well, let me hear the
Personal
answer.
knowledge of the telephone call.
Not sure the relevance of this, frankly, so.
What did your brother say?
He called me up and said, I just received a call from Joe Early, who stated that you were on a witness list to testify in Boston. I told my brother we're not gonna
Judge,
have.
I move to strike that. I mean, how is that relevant to this case?
Yeah, what is the
Seriously.
relevancy of that? He gets a phone call and says you have to appear as a witness. So how is that relevant?
So well, I don't want to testify, Your Honor, but if I could just, I guess, ask a couple more questions on the point?
Well, Judge, it goes further into it. And I objected initially because it's total bull hearsay.
I realize that,
And
but
I think he's also trying to somehow bolster the credibility of his witness by something that somebody may have said. Just not appropriate. He's testified to facts he knows about that relate to the case in front of the
no,
commission.
that's legitimate, and I wouldn't be concerned about bolstering his credibility. I'm the one who's going to be making credibility determinations. But, as I said, I did he gets a phone call as a result of the phone call. So what's going to happen
So
here?
essentially, District Attorney Early called Mr. McGarren's brother and said, what's your brother going to testify about? Is that my understanding? So I just wanted Mr. McGarren to
There's going to be no
relate that telephone
testimony.
call.
There's no testimony to be offered as to a conversation with Mr. Early and this individual's brother, period. He's not privy to the
He can
conversation.
testify to a conversation with his brother. He had a conversation with his brother. Mr. McGarren had a conversation with his brother who works for
And
Mr.
he asked-
Early.
and he asked the brother what Mr. Early said to him.
That's what I asked. Mr. McGarren's brother works in the Worcester County.
I just don't see so what's the bottom line? What are you trying to prove here?
I just think it's something we should call the hearing officer's attention that
I don't understand. What are you trying to prove?
I'm not trying to prove anything. I'm just trying to make you aware of some circumstances that occurred in the case where the district attorney called one of our witnesses' brothers and said, essentially, what is the witness gonna?
So is that impermissible in your view?
I would argue it would be. I'm not, not doing anything about that at this point, but I just think that's information that the public and the hearing officer needs to be made aware of, that phone call took place.
Judge, this is nothing short of an attempt to dirty up Joe Early with some phone call he allegedly made. There's no intimidation here. There's nothing to do with it. And given the fact, the difficulty that we've had getting information about who the witness was gonna be, let alone what they're gonna say, completely appropriate for him to do that.
I want to make a different,
I
but
don't know why Attorney
similar
Burke is
point.
arguing. with-
Hold on, one at a time. Yeah, Mr. Kiley?
There is an assumption in the way the question is framed, that the commission, the petitioner, who has never contacted an individual to tell him he is on the witness list, is somehow to the individuals on this side. Nobody owns a witness. The witnesses are going to come and testify, and it is for us to be communicating with the same people as they should have been before they were listing him as witness. Thank you.
Here the communication wasn't with the witness, it was with the witness's brother who works in District Attorney's Early's office. He works as a detective in the Worcester County Police Department. So it wasn't a call to try to get Mr. McGeon, who is equally available to everyone.
So when I ask you, what's the end game? What's the point you want? It's got to be something more. I think you should hear it. What conclusion are you wanting me to?
Well, I'm not going to draw
from
any
hearing
conclusions. I
this?
just wanted to bring the information to the hearing officer's attention, which I think I did. I don't have any further questions on the
Okay,
issue.
well, that's good.
And may I have one moment, please?
Come on, take your time.
Absolutely.
I don't have any further questions, Commissioner Kemp. So I did want to clarify that I think I misspoke that Mr. McGeon's brother, he testified accurately that he works for the Worcester Police Department, not the Worcester District Attorney's Office. If I said he worked for the Worcester District Attorney's Office, I misspoke.
I appreciate
Thank you
that.
very much. I have no further questions for Mr. McGeon.
Attorney McDonald, thank you. Attorney Burke, since you're standing up, I'm assuming you're going to do the first cross-examination.
Good afternoon, sir.
Good afternoon, sir.
Have you ever met before?
We have, sir.
You retired in 2011?
Yes, sir.
I'm sorry. What was your rank at the time?
Trooper.
And promotional exams?
No interest in that, sir, no.
Okay. And what do you prefer to be called today?
Jamie's fine, sir.
All right. Call me Tim. So Jamie, did you look at, you've read this arrest report, right?
Yes, sir.
I mean, how many times do you think you've read it?
I read it earlier this afternoon, and I just read paragraph 9 alone here today, so twice.
So are you familiar with the background of this case?
Just my only knowledge of this case is what was out in public, sir. I have no direct knowledge of this.
Have you ever spoken to Trooper Sevier to find out what his reason was for including the items that are contained in paragraph 9 that became the subject of an impound order?
I've never spoken to him, sir.
Okay. Now, you had said that, and correct me if I'm wrong, but you said that you wanted to document a police officer's actions, right?
Yes, sir.
And he does that reasonably well. Wouldn't you agree? Have you take a look at it now with me?
I would agree in some circumstances, and some I would say that,
Not so good.
well, specifically, he said that somebody failed the standardized field sobriety test. They only indicate impairment. It's not a pass-fail situation, sir.
Okay, well, he says that 3 times, doesn't he?
Yes, sir.
He says that I consider that a fail 3 times.
I know he
Maybe
said,
it's 4. Nystagmus gaze starts with that, right?
He doesn't say that about the horizontal gaze nystagmus test. He says it about the walk and turn
Okay,
and the one leg stand, sir.
all right, so you would agree with me that to arrest somebody, put them into custody, is to make the determination that probable cause exists, right?
Absolutely.
And you know the obvious definition of probable cause, right?
Yes.
And you teach that, right?
Yes.
And what you said too was that at certain junctures, you have to have probable cause, particularly in an OUI or any case, actually. You have to have probable cause before you can arrest that person, right?
I teach that you need to have probable cause for every element of the crime, not the crime itself. There's a big difference in my eyes.
Okay, even better than suggested. But it's step by step, there are certain things you make observations about that give you in totality probable cause to make the arrest,
Yes.
okay? And one of the first things he does, he makes all of his visual observations about the accident itself, right?
Yes, sir.
And then he makes observations about the smell of alcohol on her breath, said it was immense, significant, right?
Yes.
Bloodshot eyes,
Yes.
makes the determination that she's unsteady on her feet.
Yes.
He also makes the determination that she can barely keep her eyes open. He has to tell her to open her eyes, right?
Yes.
And she can't, she's having problems ambulating.
Yes.
And of course, he sees the boyfriend off the side. He looks like he's strung out, didn't he?
I didn't really pay attention to what he wrote about the boyfriend.
Okay, but I'm talking about the report. The report is supposed to consist of observations of the person who's making the arrest, right?
Yes.
And at some juncture, he has probable cause to make that arrest, right? Based upon his observations and the field sobriety test, right?
Yeah, prior to any testing, he would just under Commonwealth v. Blaze. So that initially, just what you described is probable cause for that arrest.
Okay, and part of that probable cause was the horizontal gaze nystagmus, right? And then it's the walk and turn test,
Yes.
and she fails that miserably, correct?
I would say that the test indicated impairment, sir.
Okay. Well, whether it's pass or fail, forgetting for the moment what you teach, would it be fair to say she failed that miserably?
I know it's not a case of semantics, but I would never say that. I would just say that test indicated impairment.
Okay, the wet and leg stand, that's the next part of his,
My response would be the same for that, sir.
okay. He says, I deem this test to be a failure, right?
He did say that, yes.
And again, before he makes the arrest, she says, Bebo then began hysterically crying and screaming that she was sick and a heroin addict, right?
Yes, sir.
Did he charge her with possession of heroin?
Not to my knowledge, sir, no.
Did he charge her with possession of paraphernalia, drug paraphernalia?
Not that I'm aware of, no, sir.
They found numerous syringes in the back of the car, right?
Yes.
And that was something he could have charged her with, right?
He could have had those tested
Okay.
for that narcotic analgesic and have it analyzed for a charge, yes.
Paragraph 7. He asked her how much alcohol she drank,
Yes.
right? And she said only a couple of drinks, was it?
I believe she responded 2 nips.
2 nips. And he found a heroin kit.
Yes.
Right. When you teach at the academy, do you also teach anything stigma associated with victims of heroin addiction, opiate addiction? Is that part of the class information?
I guess I wouldn't understand the question, sir. Like I would never train an officer to pass judgment on somebody.
I'm not asking
That's-
that. I mean, is there any training given to the members of the recruit classes regarding feelings of empathy and understanding
Yeah.
people who, I'm sorry.
Absolutely, yes.
Okay, that's the question.
Yes.
All right. And after he does the other test, he has conversations. He says he returns to his cruiser to transport Ms. Bebo to the Holden State Police Barracks for booking. Now, at this point, in order to transfer her, she's got to be handcuffed.
Yes.
He's placed her under arrest, right?
Yes.
And probable cause has to exist at that point in time, correct?
Yes.
Okay. So up to that point, all his observations have been used to demonstrate that there was probable cause for her arrest. Fair to say? And after that, and as he's transporting her back, you see paragraph 8?
Can you refresh my memory with that, sir?
Sure. You want to pick it up, take a look?
Yes, sir.
It's on second page, I think. When you finish that, okay?
Yes, sir.
All right, so the first sentence says, quote, "I returned to my cruiser to transport Bebo to the Holden State Police Barracks for booking. Upon entering my cruiser, I observed an odor of an alcoholic beverage that was not present prior to my arrival." All right? Now that has relevance to the crime that she was charged with ultimately, right? Oh, you,
Yes.
okay? And the next sentence after the tow truck sentence, the bottom sentence, you see what I'm referring to?
Yes, sir.
And this is, again, after probable cause has been established, and we know what she's charged with, right? He says, quote, "During transport, Bebo hysterically screamed and cried and stated, in quotes, 'My dad's a fucking judge. He's going to kill me,' end quote. Bebo was brought into the booking area of SP Holden." You see that statement
Yes.
about her dad? Now, you testified that statements should be included that are, quote, "applicable to the crime itself." You would agree with me, she wasn't charged with possession of heroin, right?
No.
Can you tell me what crime that statement is applicable to? What offense that she was charged with? If it's consistent with what you testified should or should not be in that report?
In my personal opinion, it just shows she's kind of irrational, which goes along with being impaired.
Well, how about this? Ms. Bebo was irrational. Saying the same thing, but in a less intrusive manner
It's
that's
certainly,
not relevant to a particular crime.
I would agree, but I would also agree that you, sir, along with the other respective council members, would ask, what do you mean by that? If it came
Well,
up on the stand.
but that's not the issue. We're not having an OUI trial here. You understand the distinction, right?
I do.
My question, again, there is no relevance to a specific crime that she was ultimately charged with that complies with your statement that the statement should be applicable in itself. End quote. That's true, isn't it?
It is true, yes.
Thank you. Now, can I have you go, incidentally, this report, he gets dispatched about 7:35 that night, right? First page, first paragraph.
Yes.
Do you know what time she was released by Ms. Bebo?
I don't, sir. I have to look at the report to refresh my memory.
All right. About sometime after 10 o'clock that night, about 3 hours later.
Okay.
Does that refresh your memory in any way?
Yes.
Okay. And the bail commissioner has come and administered whatever bail decision she did
Objection.
prior to her release.
What's your objection?
There's no evidence about any of these actions by the bail commissioner.
Okay, well, I gave you a little leeway. I'm gonna give the attorney, the respondents, a little leeway also, so that's overruled.
Do you know whether or not she was bailed out?
She was.
And do you know what kind of bail was imposed on her?
It says released on her own recognizance, so I would assume that she paid a $40 fee and she was released to a sober, responsible party.
Okay. Do you know, if you look at the last sentence, you see at the very last sentence, it says, quote, "Bebo was released on her personal recognizance and picked up from the barracks by her father," end quote.
Yes, sir.
Did you see that?
Yes, sir.
And does that indicate from the content of this document as to what took place that night in terms of her release?
Picked up by her father.
Do you know anything about the conversation that was had between Trooper Sevier and the bail commissioner before Judge Bebo arrived to pick up his daughter?
No, sir.
Do you know whether or not she initially set bail at $240?
I do not, sir.
Do you know, and I asked you before, have you ever talked to Mr. Trooper Sevier about this case? You have, right? No. She also take a breathalyzer?
She did, sir.
And fair to say that that was not a passing response, right?
No, it's above the per se limit, sir.
Now, you also said that there has to be quotes about pertinent information. Do you see where Mr. Trooper Sevier says that Miss Bebo, it's in paragraph 8. Jamie,
Yes, sir.
you see where it says Bebo made inappropriate comments implying sexual favors for leniency. Now,
Paragraph 9, sir.
that's in paragraph 8, it's on the 3rd page. Take a look. You see what I'm referring to?
Yeah, I do, yes, sir. Yes,
Nothing in quotes there, right?
yes, sir.
Actually,
I agree with you. It is not in quotes there. He is paraphrasing.
okay. So apparently what your training is, there's some element of discretion that can be used by a trooper writing his arrest report, substituting a paraphrase of the actual quote. Is that acceptable?
In certain circumstances, yes.
Okay, would that be acceptable here?
If we're talking about an OUI drug case and something implies that at one point she had possession or ownership of a drug, maybe it is applicable.
Okay, well, that's not what's being said. She's
Not in the paraphrase.
just a moment, please. That's not what she said, and that's not what he reported. He's talking about sexual favors, not anything about alcohol consumption or drug use, is it?
She talked in her. Well, according to the, if I look at this report as a whole, she has
I'm not
constricted.
asking about it as a whole. Sorry to interrupt you, but I'm referring to that one statement in which he paraphrases as opposed to, as you had indicated, they should put things in quotes, right?
To me, it shows ownership and possession of something in which would be attributing to OUI drugs.
Bebo made inappropriate comments implying trading sexual favors for leniency.
That's not,
That's what you
that's,
said.
no, I agree with you with that. I thought we were on the paragraph 9, sir.
No.
I would agree with you with that.
Now, I represent Major Anderson, right?
Yes, sir.
Did you ever work for her?
No, sir.
Never knew her before?
No, sir.
You would agree that very few females are able to achieve the rank of major in the state police based upon your history. Wouldn't you agree?
Yes, sir.
And have any information she's not capable and qualified to perform her functions as a major?
I do not, sir.
And when you said before that you have never been familiar with a circumstance in which a major has reviewed an OUI report, that's something that's commonly known to members of the troops, 1,000 troopers. Every time or whenever a trooper, a major or higher up reviews a report, is it? That's not announced, is it?
No, it's not announced.
And when you're talking about that, whether or not a major in your experience has ever had a chance to your knowledge has ever reviewed an OUI report, were you referencing what Jamie Conant, I think I'm pronouncing his name right, the sergeant who was on duty that night, he's the one that reviews it initially, right?
We're talking about, yeah, reviewing and stamping that for approval.
Right.
Yes.
It's very different than somebody else who has, who's in a higher rank, gets a report that's problematic brought to their attention. Nothing unusual about that, is there?
No, not at the troop level.
Okay. Well, she was troop commander of C Troop, right?
Yes.
Now, you had said there is a process for changing a police report, right?
Yes.
And is that referred to as a supplemental report?
Yes.
Did you know that this report was marked revised on October 17th? Or had the words revised October 17th,
I have
2017?
no knowledge of that, sir.
Okay, so when you talked about a supplemental report, if they had substituted the word supplemental instead of revised, it's the same consequence, isn't it?
No, not, in my own personal experience, when someone has found an error in my report, that report stays as is. I would write a supplemental report to try to correct what someone else observed, whether it was
Okay.
my detective lieutenant or a DA or somebody.
Have you ever, in your experience, Jamie, have you ever had a situation where a judge has found to be potentially prejudicial to the person you arrested and went to the extent of issuing a impoundment order of your report?
No, sir.
You've talked about your experience and your training, and obviously you're very careful about what you do. Wouldn't you agree?
Yes.
You teach it.
Yes.
Wouldn't you agree with me that it's very unusual for a judge to find a report to be so prejudicial because of its content?
Sir, I wouldn't know that that's gonna happen.
Seldom happens though, right?
I just wouldn't know if it did happen. I wouldn't know that unless a DA, district attorney's office told me it happened.
Okay. Did you know that happened in this case, that a judge ordered it to be impounded because of its content?
I first heard that in this room this afternoon, so I didn't know that.
Bear with me a moment, please.
Yes, sir.
Has the training changed over the course of time that you've been responsible for that?
As far as what?
Well, just as life progresses, as policing progresses, your training keeps up with it, doesn't it? In terms of,
Yes. Training is constantly changing.
and I've noticed you have an inordinate amount of seminars that you've attended.
Yes.
How would you estimate? 100?
I haven't looked at my CV in
200?
a while. Many, sir. Yes.
That's all I have at this time, Judge. Thank you.
Thank you. Who wants to go next? It's Missy.
I'll go quickly.
Don't hold him to that.
And now I won't know.
That was a comment to my brethren. I think that you know that I'm now Tom Kiley, correct?
Yes, sir.
And that I represent District Attorney.
Yes, sir.
And we've never met, have we?
No, sir.
But we have conversed, haven't we?
Yes.
And when we conversed, it was through you were assisted, or the contact was facilitated by an attorney who represents the unions, SPAN union, correct?
Yes, sir.
And during that conversation, you indicated, did you not, that the majority of your training with respect to report writing came largely in the field when you were in the district attorney's office in the Western District?
Yes, that and when I was in the field assigned to a state police detective unit as a undercover narcotics officer.
And that in the field training consisted in part in terms of interacting with assistant district attorneys, correct?
Yes.
And in the period of time when you were dealing with crimes, as you testified to, major crimes were generally prosecuted in the Superior Court.
Yes, sir.
And the reports that you prepared and provided to the district attorneys, the reports that you prepared in those cases went to the district attorneys and assistants, did they not?
Yes.
And they decided what to do with the reports, correct?
I guess, I don't understand what you mean, they decide.
Let me step back. You didn't file reports, arrest reports in those cases in the district court, did you?
Those reports were reviewed by my detective lieutenant as well as the district attorney's office, and then we would file those. We don't have a court officer in the district attorney's office, we file those.
In practice, the reports go to the district attorney and are not part of the charging document itself, correct? What, you
Yeah,
don't
I
understand?
wouldn't know, sir. I honestly wouldn't know. Once I turn that over to my boss and the DAs, I really don't know what happens.
You do know that in the Superior Court, cases are indicted, correct?
Yes, correct. They're
And the charging document is an indictment, not a complaint, correct?
yes, sir.
And you do know that grand jury, that information that is put into the grand jury disclosed to the defense,
Yes.
but not generally disclosed to the public, correct? With respect to the report writing that you taught over the course of time, did you teach that there are all different kinds of reports?
Yes.
And that what one might include in one type of report might not be included in another?
Yes.
In your review of this matter, and the comments that are directly quoted, was there any intimation in the material you reviewed that there was any inquiry into trafficking?
Not to my knowledge, no.
Have you ever, are you aware whether there was a question, whether the state that are attributed in the report to the young lady could have given rise to a human trafficking case?
I am not aware of that, sir.
Have you ever taught a class with respect to that would deal with the elements of human trafficking?
No, sir.
So with respect to your specific area of expertise, and you have testified on occasion as an expert in some cases, correct?
I have.
And if you were to characterize for us your specific area of specialty, is there such a thing?
Relative to me?
To your, what you teach and what you are, yes, relative to you.
I would say standardized field sobriety.
And now with respect to, strike that. We all have, and you were shown what was described as your VTAR, correct?
Yes, sir.
Do you still have that there?
There's a copy of it here, sir.
I'm going to offer it as an exhibit. It was not offered as an exhibit.
CV, is there any objection?
No objection.
No objection, any objection from any of the parties? No, hearing none, thank you. Thank you, sir.
We would have the stenographer.
No, you don't.
Oh, I'm sorry. Oh, I can you,
I'm handed one.
oh, okay. Can you just,
We want the stenographer to mark the exhibit.
Okay.
That's what we were trying to do.
And then
Yes, you will have the actual exhibit. Thank you.
would you like one?
if you want to give me one? Ms. Kylie, you're redefining the term brief on
I told
cross-examination.
you.
I know, I'm not being critical, just observational. So,
And Your Honor, just so everyone knows, that was exhibit 13.
okay, exhibit 13. Okay, thank you.
Is this a document, exhibit 13, that you prepared?
Yes, sir.
Does it training? What of the training you received as opposed to the training you provided?
Yes, sir.
Is there any specific training on here that deal in your categories of specialized training that deals with report writing?
Specifically, no, but those are all kind of subsections of several classes I've been to.
Classes you've been to. Now, with respect to the training you have provided and the positions that you have held, in terms of timing, so that I understand this, you taught the 80th and the 81st, and you gave us dates.
Yes, sir.
Do you know, would you know Trooper Skeevier if he walked into this room?
I would not, sir.
Do you know whether you taught Trooper Skeevier?
Sir?
Do you know whether you taught Trooper Skeevier?
I believe he was in possibly the 82nd RTT.
My question is, do you know whether you trained him?
I don't know that, sir, specifically.
You don't, I believe it's been admitted, set a slide deck, let me call it that. You know what I'm referring to?
The PowerPoint, sir?
Yeah.
Yes, sir.
You told us, I think that some of the material goes back to when you were in the department.
Yes, sir.
When was that?
April 1st, 1996 until October 31st, 2004, sir.
And you told us that you taught the 80th and the 81st and some on the 82nd. You gave us dates. Do you know what you taught in the 81st?
I taught report writing, interview and interrogation, courtroom testimony, standardized field sobriety, drug recognition, chemical breath testing. I may have taught an introduction to criminal investigations. I don't recall all of those courses, sir.
Were you, and you talked also about your own educational background, any training whatsoever in the professional responsibilities of prosecutors?
I do not, sir.
Do you have any knowledge whatsoever of the special obligations that prosecutors may have? Is it a subject that in any way, district attorney's office?
Prosecutors' responsibilities?
Yes.
I'm sure there was conversations about that, but it's not something I would have to retain. It's not wasn't my job, sir.
And the decisions as to what would be used in evidence in a case guided with the district attorneys in the cases you handled, did they not?
Yes.
Thank you. Mr. Scarney. Thank you.
Yes, sir.
Good afternoon, Trooper. Do you mind if I call you Jamie? Is that all right?
Yeah, I'm no longer a trooper. Jamie is fine, sir.
All right, so you can call me Mike, so we're on the same page as far as that goes. I guess Attorney Burke hit on a lot of the points that I was going to hit on. I just want to go through the report briefly, though. You referenced something about OUI detection, and I believe it's the National Highway Traffic and Safety Administration. Those materials and guidelines are the subject of the classes you teach with respect to OUI detection, right?
That's correct.
Okay. So they address, the elements of the crime, they address report writing and things that you've already testified to that I don't want to belabor, if that's fair to say.
Yes, sir.
But you did stress the importance of direct quotes as they pertain to specific elements of crimes, correct?
Yes.
You said that, to you, it's not a crime as a whole. There are specific elements you need to meet. And if you don't hit those elements, just one of them, legally speaking, there's no crime. Is that fair to say?
Well, you don't, not that there's no crime, you don't have probable cause for the crime.
Well, that person can't get charged with the crime, right?
Correct.
So that's what I mean. Legally speaking, that person cannot be charged in a complaint.
Yes.
So with respect to operation under the influence of alcohol or liquor, I know they're separate and distinct, but they do contain the same elements for the most part, right?
Yeah, Attorney Viscardi, can you just speak slightly slower?
Sorry.
Okay, no,
I
it's
should have warned everybody before that, Judge.
I'm the same way, so just, I'd appreciate it. Thank you.
OUI drugs, OUI alcohol, separate and distinct charges before the court, but they share many of the same elements, correct?
Yes.
Operation is one of those elements, correct?
Yes.
Now, if you wouldn't mind grabbing, I forget what exhibit it was, it's the report that we've been referencing.
Yes, sir.
Direct your attention, paragraph 2.
Yes, sir.
Direct your attention to a statement that Babode stated that she was the driver of the vehicle and the sole passenger identified Babode as the operator.
Yes.
You agree that establishes operation, correct?
Yes.
That's not a quote though, is it?
No, it's not.
Paraphrasing, right?
Yes.
But nonetheless, sufficient, at least with respect to that.
Yes.
So operation established, and in this public way, which we don't really need to get into, there's no debate that she was in a public way. I guess the most important part, once operation is established, is the impairment. Obviously, alcohol, drugs, that's where they differ with respect to impairment detection. Is that accurate?
Could you state that again, sir? I'm sorry.
So OUI alcohol and OUI drugs, there are different you're required to prove those using different means, correct?
Well, standardized field sobriety is still the basis for drug recognition in operation, so you would use those standardized field tests themselves.
But you are aware of the Commonwealth versus Gerhardt that stated that you can't testify as an expert that field sobriety tests have any specific correlation to drug use, correct?
I'm well aware of that, yes.
Okay. So like what I'm getting at is that I'll just cut to it, the DRE program. You have to establish not only what substance they consume, but how that substance affects the central nervous system, correct?
Well, a category of, not a specific substance, but
Yeah,
a
right.
specific category, yes, sir.
Exactly, so depressants, stimulants, things like that.
Yes.
And alcohol, a lot more straightforward, you have per se and you have impairment, correct?
Yes.
So per se is just if your BAC is 0.08 or above, legally speaking, you are impaired. And conversely, you can find impairment without the BAC just based on your observations of the standard field sobriety test, correct?
Yes, that's Commonwealth versus Blaze. You can find impairment below 0.08 as well, but there's no permissible inference of intoxication. That's 06 and 07.
Correct. So just going through that second paragraph, there's also a notation. She appeared lethargic and groggy. Her eyes were nearly completely closed. Her eyes were bloodshot and glassy.
Yes.
Now, part of your training programs, you alert the trainees that these are cues, usually to get an exit order to establish, correct?
Yes.
It's the first time you speak with someone, they're typically in the driver's seat or near the vehicle, correct?
Yes.
Okay, so those serve as probable cause to exit a vehicle, but also serve as probable cause or reasonable suspicion to further take a traffic stop and turn it into something more, right?
Yeah.
So in this case, she's outside the vehicle, she's already in it, she's driving it. He makes these observations. Immensely strong odor of an alcoholic beverage emanated from a person. And obviously you train, the trainees that it's the carrier, it's not the alcoholic beverage itself, it's alcohol's odorless, but nonetheless, they had consumed enough of the carrier to emit that odor, correct?
Alcohol is odorless except for like the fermentation
Fermentation process,
process,
yes.
so that kind of gives it a distinct odor.
Right. So again, another reason to suspect that this person's operating under the influence warrants further investigation. Fair to say. Did a query of her history. As a result of that, asked if she had used heroin today. She replies that she had done heroin at approximately 9 a.m. on this date. You follow along with that?
Yes, sir.
Have you seen any quotes yet?
No, sir.
Fresh track marks on both of her elbows, swayed from side to side, spoke with a slur. She made a claim that she had swerved to avoid something in front of her car. Do you see any quotes with respect to that either?
I do not, sir.
Let me get into the field sobriety testing. Not necessarily things that need to be quoted, just physical observations, correct?
Yes,
And you said that she, I don't need to belabor these, but walk and turn test, you'd agree that she showed several cues of impairment, correct?
yes,
And the one leg stand, again, reading that, you agree that in the one leg stand, she exhibits several cues of impairment there as well, right?
yes,
There is one quote or two quotes that she was, quote, sick, quote, a heroin addict. So at this point, she's essentially admitted she, A, used heroin, B, was driving the car, and based on his observations, she appeared to be impaired. Was that a fair assessment of this up to this point, correct?
yes,
Right, so in your opinion, this probable cause to arrest her at this point, correct?
yes,
Now, you've been a trooper for a while, you see thousands of arrests. I imagine you were in court for pleas, trials, things of that nature.
yes,
You familiar with the plea process?
yes,
Continue without a finding versus a guilty finding.
yes.
Would you agree with me that you have seen pleas to guilt or pleas to warrant a finding of guilt on much less than what's in this report?
At times, yes,
And I'm sure times more, correct?
yes,
She had admitted to drinking alcohol and was taken into custody. There's one more quote that just says she had 2 nips. Again, if she had 2 nips or not, I'm not sure it's relevant, but that's in quotes. And Judge, if you'll just give me a little bit of leeway, I promise I'm going to get to my point, but it might appear like I'm deviating a little bit.
Okay.
Trooper, with respect to the standard field sobriety testing, you're taught in the academy, or you were taught and you subsequently teach now, that there's a reason why you have these diverted attention exercises, correct?
yes,
So you have live people come in and try to perform these exercises. That's accurate?
yes.
And some of the people are given alcohol and some of them are not?
Majority of them are given alcohol.
Okay. And my understanding of, again, I don't know, I don't think it's a widely accepted science, but at least with respect to the academy, they teach there's a correlation between one's ability to perhaps, just as an example, stand on one leg for 10 seconds, could suggest that person is BAC around a 0.10. Does that sound familiar? I don't know the exact numbers, but there's a,
So
you can go ahead.
So the scientific research and data behind the one leg stand is that one person who's above a 0.08 can stand on one leg in a straight leg manner, approximately 6 inches off the ground, for up to 25 seconds. Where they falter is 26 to 30 seconds, and that's why it's a 30-second time test.
Gotcha. And for the similar reasons, that's why there's a walk and turn and an alphabet test and a count backwards. That's fair to say.
No, there's 3 standardized tests: horizontal gaze nystagmus, walk and turn, one leg stand. Alphabet counting backwards are not part of the standardized testing. I never taught anybody or instruct them to have somebody count backwards. If I instruct somebody that they want to give the alphabet, they're instructed by me to give it A to Z and A to Z only.
Sure. So, but back to the standard test then. There is a science that, as you said, correlates to one's blood alcohol content and
Yes,
the
it would be-
ability to do the tests,
There would
correct?
be 4 clues on the horizontal gaze nystagmus, 2 clues on the walk and turn, and 2 clues in the one leg stand. There is approximately a 93% reliability ratio if that person is above a 0.08.
You stated earlier that some of the statements you heard in this report reflected someone who was being irrational. That's fair to say.
Yes,
There's no science that correlates a level of intoxication as to someone's irrationality, correct? It's just this person may or may not be drunk, right?
there is not, correct.
All right, and you'd agree in this report, you haven't even got to paragraph 9 yet. I think you've testified this is ample evidence, not only for probable cause, but presumably for someone to admit to sufficient facts to warrant a finding of guilt. You agree with that?
I'm not, my personal opinion, yes, but everybody has discretion, so I can't really say what other people would think on that.
Okay, but again, you did say that you've seen people in court admit guilt or warrant findings of guilt on much less, correct?
Yes.
And I'm just going to draw your attention to paragraph 9. Second sentence. Babode admitted to using heroin in a state and stated that she had acquired
I'm
the heroin.
sorry, Your Honor, could you ask?
I'm sorry.
Okay, okay.
Babode admitted to using heroin on this date and stated she had acquired the heroin this morning for her and her boyfriend.
Yes,
You would agree that that establishes possession of a substance that she may have consumed before operating motor vehicle?
yes,
So that's sufficient.
yes, could be, yes.
One moment, Your Honor. I don't have any further questions.
Thank you. Bourgeois, you have any questions? No?
Good afternoon, Mr. McGarry. I'm Roy Bourgeois. I represent the respondent. And I've just got a couple of questions I want to ask you, and one of them is going to be a silly question, okay? It's going to be a silly question. If we were to take the exact circumstances of this arrest as set forth in the arrest report and add one fact, and that is that in the back seat of the cruiser, the defendant, Ms. Bebo, was singing Jingle Bells out loud. Would you expect the report to have all 4 courses of Jingle Bells written out verbatim?
Most likely not, sir.
Okay. And would it be appropriate to summarize and say she was singing Jingle Bells?
Sure.
Would it be appropriate to say she was singing Christmas carols?
Yes.
And that's because none of the specific words really bear on the elements of the offense that she was being charged with, correct?
Yes.
And because the trooper, in his professional judgment, can write words that allow people to understand things without direct quotes. Isn't that true?
Yes.
Now, you said that you learned here for the first time that a judge actually impounded the entire arrest report and probable cause statement. You didn't know that before, right?
I did not, sir.
Okay, and you learned also that the judge did that because he felt that the quotes that were in the report were so inflammatory as to potentially impair the defendant's right to a fair trial. That's something else you learned today, right?
Yes.
Okay, so isn't it true that the way in which something is written in a report, whether it's in quotes or whether it's summarized, is a matter for different professional judgment among different police officers?
Yes.
And you're not saying here that other experienced professionals couldn't come to a different conclusion than the opinions that you stated, right? You're not saying that, are you?
I am not, sir.
Reasonable, honest police official could come to a different conclusion about that quoted language and not necessarily be motivated by anything like corruption or anything like that, right?
It would, I don't know. They could have their own, everybody would have their own conclusions.
Right. And that would be a reasonable professional conclusion that someone could reach that's different from yours. Isn't that right?
Sure.
That's all, sir.
Thank you very much. Anything on
Thank you, Presiding Officer Kantorowicz. The petition does not have any further questions for Mr. McGarry.
You could have said that from there in a nice
Why don't you
loud
just put the,
voice.
pick it up?
What, if it's a nice loud voice, you would have.
No
thank
further
you.
questions, thank you.
Okay, thank you, Mr. McDonald. Ms. Brooke, you have any other questions based upon what your fellow respondent said? No, Mr. Swarsoni, anything based on what Ms. Bourgeois said? Okay, well, sir, thank you very much.
Thank you, sir.
Okay, well, thank you.
Yes, sir.
Yeah, there you go. Okay, next.
That's all we have for today, Commissioner.
Okay, well, I'll just note for the record, we're 2 hours short of, we have 2 more hours to go. And unfortunately, you don't have any other witnesses. And once again, I appreciate the problems, but I also, having done a lot of litigation in my life, realize that my order could not have resulted in the paralysis that you're indicating. So, so tomorrow, what witnesses are you planning on calling?
Calling our expert at 10:15.
Okay, and what's the name of that expert?
His name is John Goldberg.
Okay, and at, okay, 10:15 expert, and his name is what? John what?
Goldberg,
Okay, can you just, for the record, spell his last name?
Goldberg.
Okay, and what's he gonna testify to, basically?
He'll be testifying to substantial value.
Okay, oh, good. So, now is he gonna be,
He will be via Zoom because he's in New Jersey.
okay, so that's not a problem. Now, how long do you suspect that he would be?
I think his direct would be rather short, say 30 to 45 minutes. I don't know how long 4 cross exams will be.
Okay,
And I don't know whether the hearing officer would have any questions either.
I respect that, and I also respect that some cases go longer or shorter. So I'm just giving you, I'm asking just very general, and I appreciate your expectation. Once again, I'm not gonna hold you to it. The length of the cross-examination of this expert witness, I'm looking at you, Ms. Burke, initially.
Minimal, Judge,
Okay, minimal.
whatever that means.
Probably the same amount that I did today.
Okay,
They're probably asking any questions, to be honest.
okay.
And I might go a little bit longer with him. By the way, his first name is John, Jon.
Oh, okay, okay. Okay. Now, okay, that's one witness. Now, what other witnesses can you call? And if the witnesses can't come in because it's inconvenient, I appreciate that. We can just have them testify via Zoom.
Yes, so we have contacted counsel for 2 of our witnesses. Neither of them are available tomorrow. And we are contacting counsel for 4 other witnesses. Those are the court personnel, and we will find out if they're available tomorrow.
So are there you have any witnesses who don't have counsel?
I think that was the only one today.
Yeah, well, going forward, what witnesses are you gonna call who don't have counsel? Once again, I don't, it's just for information.
No, I don't believe we have any witnesses who do not have counsel.
Okay, so you have like 7 or 8 witnesses who have counsel?
6.
Okay, 6 witnesses. Okay, now I take it you're not expecting any of these witnesses to take the 5th. They just want counsel. I'm not quite sure why they want counsel, maybe just to make them feel at home. So you don't anticipate any witnesses taking the 5th Amendment, do you?
Not to our knowledge.
Okay, so the counsel is here merely to provide comfort and advice?
I'm not sure I understand the question.
I'm just
I mean, we
trying
haven't
to,
asked the council why they're coming here to represent the witnesses. We haven't asked that question.
okay, well, you're an experienced attorney, you know what the witnesses are gonna say. What's your best view on why they need legal counsel other than to provide comfort and advice if need be?
Yeah, I am completely uncomfortable speculating as to why a witness would want to have the counsel of his or her choice representing them before an adjudicatory proceeding.
But you are comfortable that there's no 5th Amendment, right?
Not that I am aware of.
Okay, well, okay, so tomorrow there's 1 witness. So are there any other witnesses? You realize that, yeah. You realize we said 9 days of trial, and from 9 in the morning or 10:15 in the morning to 5 o'clock. And it was expected. We were really gonna kind of try to plow through as much as we possibly can. So, as I said, I'm greatly concerned that, you know, you have a witness tomorrow that may be here for an hour and we're 2 hours short today. So, you know, we're losing literally 6 hours of testimony. So I think you can appreciate my frustration. So why can't you get any other witnesses? Especially, you don't have to worry about the schedules of counsel.
Yeah, I apologize. I don't understand the question. Are you suggesting that the witnesses should appear without the attorneys of?
No, I'm saying,
Oh,
no, not
okay.
at all.
Oh,
I would, no,
okay.
I share your concern. If someone wants to come with an attorney, I have no problem with that. That's no
Okay.
problem at all. All I'm saying is that I asked you the question, how many of your witnesses have attorneys? You gave a number, I believe it was 6, and I respect that. And apparently the 6 attorneys will all happen to be busy tomorrow. I respect that. All I'm saying that means there's a host of other witnesses you have who don't have attorneys and they don't, you know, so we don't have to worry about the schedule of the attorneys.
All of our outstanding witnesses are represented by counsel, and I just want to make sure, I don't want to yell from the corner.
No, it's
Make
okay.
a sort of disembodied voice.
I appreciate
But all the witnesses are represented by counsel. 2 witnesses are represented by 1. 4 witnesses are represented by 2 attorneys in the trial court. So the 2 ADAs are represented by an attorney. He said that they're not available tomorrow. And we're in contact with the attorney in the trial court to find out if any of the 4 other witnesses are available tomorrow. So we really are trying to get additional witnesses. But I hope the presiding officer can appreciate how the petitioner's case has been sort of upended by some of the recent events and orders that have occurred in this case.
No, I appreciate what you're saying, but as I said, I just don't accept that you reach a level of total paralysis as a result of an order that was rescinded 3 days later. So my question to you, though, how many witnesses do you have? Why don't you stand up there? How many witnesses, unless you want to yell from there, which, you know, I want to make it easy for the court officer. Yeah, I'll get to you in 1 second.
Simple question.
Yeah.
Could the chair inquire whether the witnesses have been subpoenaed?
Okay, I will, fair enough question. Yeah, have the witnesses been subpoenaed?
All of them subpoenaed for a particular day,
For when?
for particular days, when we had a schedule for when the hearing was going to occur and the petition was going to put in its case in a certain order.
Okay, well, as I said, I don't care about the order. If we have to upend the order, we can upend the order. So I don't care about that. So you said that, I believe, and if I misheard, I apologize. You have 6 witnesses, all of whom have attorneys, and we have schedules. How many witnesses do you have with no attorneys?
None. Well, our expert is not represented by
expert
counsel.
doesn't
and
have-
he's-
Okay, well,
Yes.
So you,
But the rest of them are all represented by
so
counsel.
so are you telling me then you have the expert and you have 6 so you have 7 more witnesses you're gonna call and that's it?
Believe that to be true. And my only hesitation is that, based on the motions in limine that you allowed and denied today, that impacts what our case looks like going forward. And we haven't had an opportunity to sort of digest, well, who do we need now that these transcripts are in?
Right.
So we know that we're calling at least 6. I don't think there are more, but I don't want to make that representation without having gone back to see, in terms of what evidence is in the administrative record, who we still need to call, who's still outstanding. I don't know that there's anyone else,
No,
but as of now, it's 6, and I just want to make sure, I don't want to represent that it's only 6.
I appreciate that, and I realize in ongoing litigation, something may come up. But it's, you know, initially there was a witness list you know, there was initially, there was a witness list and it looked like there were like 30 witnesses. And I just had a question. Who did you originally have scheduled to testify tomorrow?
Before the order on substantial value?
No, I just, you know, who did you originally have scheduled for tomorrow?
Before the order on
Yes.
substantial value?
Yeah.
Okay, so that was Judge Dolly, Judge Despotopoulos, and Dean Ricciardi.
Okay, so those, and were they subpoenaed?
They were.
Okay, and you withdrew the subpoena.
We told them that we weren't calling them on Tuesday because we had another priority.
Okay, I'm, see, what I'm somewhat concerned about, when I indicated, because I didn't know how long your witnesses would be. I didn't know how long your witnesses on substantial value would be. So by my ordering, I want to hear the witnesses on substantial value, and you knew it was going to be relatively short. Did you have a backup plan for people to be called?
We didn't know what you were gonna do after we put in our evidence on substantial value. We didn't know if you were gonna take that information and make some sort of referral to the full commission or not. We did not know what was going to happen next. We had never been faced with a situation like that before. In the 14 years I've been on the commission, Mr. Kiley, I don't want to speak for you or to pull you into this, but we hadn't seen it before, so we didn't know what was going to happen next.
You probably haven't seen a case like this in 14 years. So,
Fair.
as different facts make different cases. So, but it's kind of good news that this, as of today, subject to what you just said, there's only 7 more witnesses to testify, and then you'll be resting.
Assuming that when I go back and look at what's in the record.
I indicated that.
Okay, I just want to make sure I'm not being held to 7 witnesses.
I hear what you're saying. So let me just ask. Well, it seems to me we're not going to need 2 weeks to get through those 7 witnesses. They literally could. We can kind of breeze through them fairly quickly in a couple of days. So do you foresee any of your witnesses being particularly lengthy or kind of comparable to what we saw today?
Comparable to what we saw today.
Okay, once again, I'm not holding you to it. I just want a general idea.
Although we do have 4 respondents who may be more interested in one witness than another. So, and I was actually surprised. I think the cross-examinations were an hour and 15, hour, 20 minutes thereabouts.
Well, I'm going to turn to Mr. Burke, having heard what we've heard today, do you have any thoughts, comments, considerations, suggestions? As I said, I saw the original witness list. I said, oh my God, there's a lot of witnesses being called, and now I'm told that there's probably going to be 6. So it says it's not going to be quite as long. So what do you?
Mr. Goldberg tomorrow, again, 6 witnesses. All the judges, I need to know that.
Yes.
So we have 3 judges going to be on?
2.
Okay.
Are they
And
going
then
to?
your Sevier. Who else?
I was going to get to that,
Right, okay.
but I'm
Can I just
glad.
ask
I'm
something?
you did it. That's fine. So she just wants to know, and totally legitimately so. So you have, your expert tomorrow, the arresting officer, the 3 judges.
2 judges.
I apologize, 2 judges. Thank you.
Yeah.
So, and then who else? Like who are the other people?
2 ADAs.
2
And-
ADAs.
And do you know who they are?
Roberto O'Brien and Ed Karskanis.
So
And-
Judge, here's just one of my many qualms here. You heard statements that they issued subpoenas for specific dates. And I understand the change up in terms of substantial value and then not substantial value. But if they had issued subpoenas for specific dates, means they knew what dates they anticipated those people were coming in. And that was issued obviously before and or during or after I had made my multiple requests for a batting order.
Right.
We still don't have it.
So here we are in the middle of the trial, and we're just still finding out for certain who they're gonna be calling.
Okay.
And that puts us at a disadvantage.
I appreciate that, and you now have the names of the 6 witnesses. Correct? We have the names of the 6 witnesses. What's that?
I count 7.
And there is the possibility, I think there is the possibility that when they review the motions today, the rulings today, and maybe we're gonna see potential for the calling of the respondents into, well, it would be in their case. So from my perspective, we know the identity of several, but we do not know, we don't know the batting order because the batting order changes.
Okay.
From my perspective, I know that Judge Dolly has been indicated its availability is for Friday, and that is something that has been communicated to me by the trial counsel for the court and by counsel for the petitioner. I know that to be the case.
However, response to the presiding officer's earlier work harder, we contacted the counsel for the trial court and asked him, of the 4 court personnel, is anyone available tomorrow, including Judge Dolly? So if that changes, I'll obviously let you know.
When will you know that? Probably no later than 5 today.
I don't know, the calls are being made. I don't know.
Well, just give me your best guess. Has anyone ever called you from the trial court after 5 o'clock?
Objection.
I don't know, did we get an email from yesterday? Yes, after 5? It's possible.
It was close to
It's
5.
actually possible.
Okay.
They're pretty responsive, but I don't wanna speak for when he's gonna call us back.
Okay, in fairness to everybody, in fairness to the respondents, they call a witness and you say, geez, we're just finding out about it. We kind of generally knew about them and we're at a disadvantage. I would ask you to cross-examine that person and then possibly recall that person after you have had an opportunity to review what he had testified to. So I'm not going to jam anybody up is what I'm indicating. So do you have, Mr. Bourgeois, you have any thoughts or considerations or suggestions?
I don't, I'm not certain that their theory that they can put in a case against some of the respondents based on just the interviews is gonna work.
Well, that's another issue for another day.
And so I think there may be, when they rest, there may be some motion practice here.
Yeah, it's, I appreciate that. You realize that, I'm the hearing officer. I'm not a judge, in the class. I'm a hearing officer. And I really cannot make real decisions, dispositive types of motions. I would have to refer that to the entire commission.
I think that's true, but you do have the authority to deal with issue preclusion orders that may be fair under the circumstances. I don't understand the concept of a witness who is under subpoena saying, I'm not going to the trial because my lawyer's not available.
Right.
The lawyer's gonna sit back there anyway.
Yeah, well, that's what, my questioning to the petitioner, exactly what is the lawyer going to do? But the sense I got from listening to the petitioner, they apparently called off the subpoena. They called their witnesses and said, that subpoena, it just seems to me when you issue a subpoena for a court date, you say, you have to come in, but, we're waiving you coming in today, but the subpoena is still in practice or it's still in force. And then you call them up and say, there's been a change of plan. Now you have to come in as pursuant to the subpoena, but that's another argument for another day. So, so tomorrow we're hoping to get the expert and possibly a few other witnesses. And then on Friday, we're getting Justice Dolly and
Trooper Sevier.
pardon me?
Trooper Sevier.
Oh, and Trooper CV is coming in on Friday,
That
okay,
is correct.
okay, CV. Okay, and, you know, I indicated my preference to stay to 3, but I'm gonna accommodate the parties as best I can. If we have to stay later, it's fine with me unless you folks have a conflict, which I'll be respectful of. So, any, Ms. Burke, you want to say anything else here?
I think that's going to add to the equation.
Okay, well, you know,
By the afternoon, I think I have to observe silence for a period of time. It may make things go quicker.
okay, you know, it starts at 3:00, right? So, Mr. Scarney, you have any comments or thoughts?
Not really, I mean, just with respect to this issue with the batting order and everything like that, I understand things have come up, but it's just, you know, I've been a defense lawyer for about 10 years now, and I understand that you always have a plan, you walk into the courthouse, and the plan, without fail, usually tends to go sideways and you have to get down. Last night, I wasn't sure if we were gonna have one witness, no witnesses, based on the transmissions back and forth, so I cut for 4 witnesses, because it was my best guess.
Okay.
Who would be here today, so I think some level of adaptability needs to be applied.
Let me just ask this question. When would you anticipate calling the 4 respondents?
Depending on what the record looks like, we don't know that we will be calling.
Oh, really?
We're not entirely sure that we will.
No, I appreciate that. So, so theoretically, you might be resting on Friday. Or at the latest, Wednesday.
It's really going to depend on whether our witnesses are available. I mean, I'm just repeating myself.
I know, you know, you have a subpoena on them, you can re-subpoena them, you know,
And
it's
they're
not.
represented by counsel.
I know.
And their counsel schedules matter.
Well, you know, as I think Mr. Bourgeois, so, you know, you subpoena the witness to come in and, you know, the witness should be here. If he needs counsel, you know, a lot of times attorneys can ask their partner or their associate to come in and stand in for them. But that's another matter for another day. So, yeah, Ms. Bourgeois.
Just a point of information, you'll recall I have a medical.
I do, oh, that's
Friday
right.
morning. My plan is to be here tomorrow for the full day, but not to be here Friday on the representation that the witnesses are Judge Dolly and Trooper Street, where I don't object to the proceeding going in my absence on Friday.
Okay.
We have another issue, which is the stipulation with respect to Keenan and Travers that is going to happen later. So I'm just going to call Clerk Keenan.
They're going to let me know tomorrow morning the block of time, whether it's next week or the week after.
It wouldn't be this, it wouldn't.
It's not gonna be this week.
It could be tomorrow,
Why could
because
it be
Keenan could be tomorrow if we get a call from Dan Sullivan that he's available tomorrow. Because we've been ordered to produce additional witnesses, so we are trying to get additional witnesses tomorrow. I appreciate that you and I had, but I've been told to get additional witnesses, and that's what I'm trying to do.
Mr. Presiding Officer, we read into the record an agreement between counsel that I would get 5 days' notice of when they're gonna call Brendan Keenan.
Okay.
Now, if they're reneging on that agreement, I renew my motion to get me severed from the case.
You know, as I indicated, you know, I'm not gonna jam anybody up. So theoretically, if she calls you by the time you get home or back to your office and says, Clerk Keenan is available to testify tomorrow, would you say, I need more time, or would you say that's okay? And I don't care what your answer is. Whatever answer you give me, it's okay with me.
What I'd say is what I've been saying all along. I want to call Mr. Travers right after, and I have a medical appointment Friday morning. I can't do it.
No, I appreciate that. I'm just saying, if she calls you tonight and says, we just heard, and Keenan can testify tomorrow, okay? So, you know, it seems to me if she says that, you know, Keenan would be the first person to testify, followed by Mr. Travers. Oh, but you may not even call Travers.
Oh, the expert is tomorrow.
Well, I realize, but you may have to call the expert, you know, as I said, if I have to take witnesses slightly out of order, I'm going to do it. And I don't want to jam up your expert, obviously, but
I think that might incur some cost for the petitioner because we've
I-
set aside that time.
I realize that, and once again, I continue to apologize to you for, but in trials, you just have to kind of be flexible. I'm just asking you, if you get a call tonight or at 5:00, she goes back to her office and says, Keenan can testify tomorrow. Are you calling Mr. Travers then? If Mr. Keenan testifies tomorrow, would you call Mr. Travers?
No, it's, my brother counsel wants to call Mr. Travers after Mr. Keenan testifies so
Okay.
that you can judge the credibility of the witnesses.
Oh, so then I would so you don't intend it, so you would call Mr. Travers, I would take him out of order, which is, as I indicated, fine with me. So I just want to repeat, if she calls you today and says Keenan can testify tomorrow morning, would you say that's okay with you? As long as Mr. Keenan testifies followed by you calling Mr. Travers,
Yes, sir.
that would be acceptable to you?
Yes, sir.
Okay, very good. So,
We'll do the expert later.
yeah, we would do it later in the day. Yeah, so, and which I hope to avoid, because I want to avoid costs, obviously, to the petition. I'm sensitive to that.
To the commission.
Actually.
Okay, to the commission. Okay, so the commission will have to absorb, and I apologize to you. So, okay, so are there any other concerns? Do you have anything? Nothing? You've been silent there? No? Okay, have a great day. Safe trip back to your offices and homes, and I'll see you tomorrow at 10:15. Okay. Thank you. I appreciate the efforts of petitioner, getting these witnesses.
So, the Zoom recording, you will get the link that will allow you to access it and download it when it's